Good morning. Welcome to the international conference titled Ensuring Uniform Judicial Practice, Forms and Challenges. Before starting, we have a short technical message. We have two languages.
Guests, and welcome to this conference dedicated to the issues of ensuring uniform judicial practice. I'd like to start with a short message regarding the language of conference and the translation. Konferencija vyks dviem kalbomis.
The conference has two working languages, Lithuanian and English, and those who want to listen to interpretation, please use the headphones. You'll also find a console, Lithuanian language channel 1, the English language is channel 2. If there are any technical issues, please ask help for our conference staff.
Two languages, either Lithuanian or English, and if you wish to listen to the translation, please use the headphones provided at your seat. In the control panel, there are two channels. The first channel is for Lithuanian and the second is for English. And in case you face any technical difficulties, please look for the conference staff located in the hall, and you can distinguish them, you can find them, they can be identified by their name tags. Na, dabar jau kalbėsiu tik lietuviškai.
I'll switch to the Lithuanian language. I hope everyone can hear me well. I would like to give the floor to Saulius Skvernelis, Speaker of the Seimas of the Republic of Lithuania. Dear judges, legal professionals, members of the academic community, esteemed conference participants, and dear guests, I warmly welcome you to the Seimas of the Republic of Lithuania, to the international conference titled Ensuring Uniform Judicial Practice, Forms and Challenges. I am delighted that this discussion is held here in the home of democracy and legislation, and that it will address issues of ensuring uniform judicial practice, which are relevant both at national and international levels. Talking about ensuring uniformity, we inevitably have to talk about the role of precedent. We all understand that in hearing cases, precedent is gaining an increasing importance not only as a value-based concept, but also as a practical tool that helps to achieve uniform judicial practice and ensure a balance between general legal principles and the specifics of individual cases. However, precedent must not be applied mechanically. In a mature legal system, precedent must always be applied responsibly, reasonably, with proper justification. It should be adaptable to new circumstances while also respecting the logic and meaning of previous decisions. Uniform judicial practice is not merely a formal objective. It is one of the fundamental foundations of the rule of law. Ensuring uniform judicial practice is a form of responsibility. It is responsibility before the law, the legal system, and most importantly, before the individual. Legal certainty, consistency in legal interpretation, and predictability are values that allow individuals to trust that their case will be decided fairly, regardless of who adjudicates it. Although the main role in ensuring uniform judicial practice is played by Supreme Courts, the legislature must provide a clear legal foundation for this. The legislature can contribute to uniform judicial practice by defining the power of judicial precedents in legal acts, clearly outlining the significance of higher court interpretations, and ensuring that laws do not leave room for contradictory or conflicting interpretations. In the legal system, precedent must become not only a practical guidepost, it should be a clearly regulated part of the law, one that does not contradict the principle of judicial independence. I have no doubt that this international event will help us find the line between a stable legal order and a living, ever-evolving legal system. I thank the conference organizers, initiators, for encouraging dialogue among lawmakers, practitioners, and scholars, and I invite all participants to actively share their experiences. I wish you meaningful discussions as well as open and bold insights. And since I have the opportunity to meet with you, I would like to thank you for your cooperation, for the whole legal system, for all legal institutions, and I wish that I hope that you are the guarantee for the consciousness in our country. We thank the Speaker of the Seimas, and now I would like to give the floor to Rimantas Mockos.
Gerbiama Lietuvos aukščiausio teismo pirmininkė Danguolė Bublienė,
Ms. Bublienė,
Europos Sąjungos teismų teisėjai ir generalinis advokatė,
honorable justices, judges, lawyers,
didžiai gerbiami profesoriai,
Mr. Goda, professors, Professor Šimkūnas,
dalyviai ir svečiai,
distinguished participants, guests, dear colleagues.
pirmiausia, nuoširdžiai leiskite pasveikinti
Let me first of all
susirinkusius į tarptautinį
warmly welcome you to this international conference at this crucial time for us. This year, we are celebrating the 35th anniversary of the restoration of the independence of Lithuania.
sistemos brandos šventė.
This is a celebration of the maturity of our democracy, as well as an opportunity to recall other
Jau buvo paminėta kvietime į šią
anniversaries that are closely related to this one.
kasacinės kompetencijos 30.
Today, we're also celebrating the 30th anniversary of the cassation competence of the Supreme Court of Lithuania. With this competence, the Supreme Court takes a very important place in the hierarchy of our courts. It has to interpret the rulings of other courts. It contributes to greater trust in the judicial system of our country. This institution makes sure that law is equally interpreted and contributes to the improvement of our legal system, thus strengthening our legal culture.
Įstatymų ar kitų teisės aktą teismai taiko ir aiškina, tam tikrais atvejais
Although the courts interpret and explain the laws adopted by our politicians, their judgments, their decisions also contribute to the improvement of our legal system. They also
taip užtikrinant teisingiausių sprendimų priėmimą.
contribute to rapid response to the societal changes and proper prevention of certain
Tikslas užtikrinti teisės viršenybę
precarious ones.
vykdymo kokybę.
Ladies and gentlemen, this court ensures that justice prevails in our society and it maintains the credibility of our system. Equal interpretation of law is vital for the trust in and confidence in society in the legal system of our country.
O kiekvienas iš mūsų teisėjai
Each and every one of us, including justices, judges, lawyers, politicians, policymakers, all of us are in charge of laying that bridge between the judicial and the executive. Globalization, digitalization, AI, international relations, all of that require consistent application of law at the national law as well as its harmonization with international standards, which is why the jurisprudence of the Supreme Court is of crucial importance, including the prejudgments of the European Court of Justice, as well as other European law. All of that contributes to making sure that the human rights do not remain but mere declaration, but actual implementation of the fundamental human rights. Certainly, there are certain challenges that we need to address, including legislative loops, the need to balance between the independence of the courts and effective implementation of law. We need to improve and simplify and make more clear our judicial standards. Ladies and gentlemen, this conference is an excellent opportunity to share experience, discuss the best practices and the solutions aimed at ensuring a universal and equal application of law. I hope this will become not only a platform for cooperation, but also serve as an impetus for improving our legal culture based on respect for law. I hope the entire legal community will not stop at that and continue improving in an attempt to find new ways how to improve even more our legal system. I wish you a successful conference. Thank you.
Dėkojame gerbiamajam Rimantui Mockui ir
Thank you, Mr. Mockus. And now for an introductory address, we would like to give the floor to Professor Danguolė Bublienė, President of the Supreme Court of Lithuania.
Gerbėmieji konferencijos dalyviai.
Dear conference participants, this year marks 35 years since the restoration of independent Lithuanian state. This period has brought new challenges and valuable experiences and significant progress in many areas. One of the most important achievements of our state during this time is the Supreme Court of Lithuania, which crowns the systems of court of general jurisdiction. Following the judicial reform, it was granted new competence in terms of quality on the 1st of January in 1995 and became a true court of cassation responsible for ensuring uniformity and interpretation of application of law. This status and role of a court of cassation stand for and aim for the highest standard of legal understanding, its cultivation and development in all democracies. Of course, legal recognition of the status was only the beginning. It takes more than a decade to achieve meaningful results. Some Western legal scholars have noted that in terms of uniform judicial practices, post-communist European countries were far behind roughly where the Western countries had been about 50 years ago. Therefore, especially with Lithuania's integration into Europe, we were expected to achieve just in a few years what Western countries had been working on for decades. Today we can also speak in terms of decades, albeit fewer of them. So what are the perspectives for achieving greater uniformity in judicial practice? These questions have been already touched upon earlier this year during the January 24th conference, marking the anniversary of the judicial reform of 1996, as well as the 30th anniversary of the establishment of courts of appeals. Our forum today is dedicated to take a deeper look into the unification of judicial practice, which is becoming an increasingly pressing challenge due to many factors. Therefore, I first thank all the speakers. Your professional authority lends exceptional weight to this conference and confirms that this topic is relevant not only for Lithuania, but also for other countries. Indeed, this topic has been on the agendas of the most recent highest-level meetings. It was widely discussed last October at the colloquium of the Network of Presidents of the Supreme Judicial Courts of the EU, analyzing the influence of European law of Supreme Courts. The topic was also addressed at the annual meeting of the Baltic Supreme Courts and again this year during meetings involving the previously mentioned network, the Court of Justice of the EU, the upcoming Baltic Nordic Forum will also discuss this issue. It is encouraging that the topic is becoming recurrent, for it allows for broader and deeper insights through comparative experiences and in-depth identification of best practices. These practices become an impetus and encourage changes. According to the Constitution, ensuring uniform judicial practice in Lithuania is not only the task of the Supreme Court, but also of lower courts. Therefore, this conference is significant and relevant to all courts. Nevertheless, the greatest responsibility undoubtedly lies with the Supreme Court. Its constitutional duty is to ensure a vertical uniformity of the practice of courts of general jurisdiction. Thus, the rulings of the Supreme Court become one of the most important sources of law, unifying judicial practice and developing the law. We have been witnessing the convergence between civil law and common law systems worldwide. In civil law countries, the importance of judicial practice is growing, while in common law countries, the doctrinist precedent is becoming more flexible. This trend has reached Lithuania as well. Our country no longer fits neatly into the binary classification of civil and common law systems. Although our substantive and procedural law is firmly rooted in the civil law tradition, changes over the past 20 years clearly indicate the growing role of judicial precedent. On the 28th of March 2006, with the publication of a constitutional court ruling, Lithuania became a country of precedent-based legal systems. As noted by former President of Supreme Court and Advocate General of the Court of Justice of the EU, Professor Rimvydas Norkus, this ruling was a significant step that compelled Lithuanian courts to take the function of ensuring uniform judicial practice seriously. But today, almost 20 years after the Constitutional Court's ruling, we are still wondering if we have developed a culture of judicial precedent that reflects the content and nature of precedents in countries with common law systems. Or should we look up to the continental precedent inspired by European law? This and the impact of European law on changing the concept of case law were discussed by Christophe Solar, first president of the French Court of Cassation. We also seek answers to other questions. Do all court decisions carry precedent value? Have we adequately changed our decision-writing techniques, especially in terms of reasoning? Do we discuss enough in universities what is a precedent? What are its features? How to determine case similarity, or how to distinguish relevant factual differences between precedents? Has the concept of judicial precedent in terms of its content and consequences become part of our legal tradition? It is also paradoxical that the term precedents does not exist as a source of law in legal regulation. Our colleague, Mr. Gintaras Kryževičius, spoke at an international conference about the legislators' intent to deepen the adoption of precedent theory by amending relevant laws, the law on courts, for example. Yet, to this day, the term precedent is not used in the Code of Civil Procedure, the Criminal Procedure Code, or the law on courts. Although the law on courts, as well as the codes, were specifically amended after the ruling of the Constitutional Court, the law on courts states that all those applying the law must take into account the interpretations provided in Supreme Court rulings. The Civil Procedure Code requires that such rulings formulate a rule of law interpretation and application relevant to judicial practice. But what does take into account mean? Is it mandatory to follow, as it is the case now, or is it only enough to acknowledge the interpretation and explain why it is not followed, thereby encouraging the Supreme Court to revisit the issue? Do only the cassation rulings of the Supreme Court have a precedent value, or do, for example, the rulings of the selection panel also have a precedent value? Does a rule of interpretation of law have to be formulated in every cassation case, or at least in the vast majority of them, if there's already a selection process that presupposes that only cases worthy of cassation are selected? Should or can a rule of interpretation of the law be abstract or linked to the factual circumstances that are clearly reflected in the rule itself, rather than being read out of the text of the ruling as a whole? Can it be said that today that the horizontal effect of precedent operates at both the district and regional court levels? As Professor Giedrė Lastauskienė once said, regardless of the de jure situation, for now we can only talk de facto about court practice as a source of law. There are more questions. Do we have enough tools to monitor and harmonize practice across district and regional courts, not only within each court, but between them? Can we ensure that there are no 5 different versions of justice across 5 regions in Lithuania? Is it reasonable to raise questions about violations of judicial independence when issues of judicial practice and its uniformity are discussed in internal consultations? Is the question raised by my colleague Marius Bartninkas valid? And his question is the following: is uniform court practice an absolute value, or does the lower court have the right not to follow the practice of the Supreme Court of Lithuania, which it considers flawed, or is it the obligation of a lower court to make a decision based on the judicial practice approved by the majority of violation of judicial independence? So how should we assess the uniform interpretation of the law and the independence of judges? How do these 2 categories correlate, and are they contradictory or convergent concepts? In raising all these questions, I want to believe that we live in a mature state where it is understood that every obstacle, every shortcoming, and every deficiency must be discussed, and that improving every sector of the state as much as possible is a prerequisite for development of our quality of life. I also understand that change takes time and requires constructive discussions. Therefore, I urge both the academic community and practitioners to raise these questions, seek answers, and find our identity, not only for the sake of the development of law, but in order to find better practical solutions that our society expects. And it is our duty as legal professionals to come up with those solutions. I will conclude with a statement that, despite being a cliché, is nonetheless fundamental. Uniform judicial practice is not only a hallmark of the rule of law, but also reflections of society's expectations for legal certainty, stability, and predictability. It is said that uniformity in law creates trust in life, and law without uniform application becomes a precondition for injustice. Once again, I thank all the speakers and participants of the conference, and I hope that the presentations will spark meaningful discussions among us all. If not here today, maybe it will happen in your workplace.
Dėkojame pirmininkei ir kviečiu įžanginį žodį tarti Vilniaus universiteto.
Thank you, Madam President. And now we would like to give the floor to Professor Vigita Vebraitė, Dean of the Faculty of Law, Vilnius University. Mr. Acting Minister, Madam President of the Supreme Court, participants of this conference, ladies and gentlemen, on behalf of the Faculty of Law, I would like to congratulate all the participants of the conference. The Dean of the Faculty, Professor Haroldas Šinkūnas, also sends his greetings and wishes everyone a successful event, although he is unable to participate in the event in person as he is away now. I have no doubt that the Dean would be delighted to see a large number of representatives of the judicial system and members of the academic community. After all, consistent case law is the result of a constant dialogue between legal science and practicing of law. When the Constitutional Court of the Republic of Lithuania established the concept of precedent in our legal system, this decision aroused such interest in the circle of legal scientists and practitioners as is caused by a truly rare court decision. At that time, questions were raised about the differences between legal systems and their convergence, and there was a wide-ranging discussion about the meaning of precedents, their binding nature, and the limits of their application. Today, as the 20th anniversary of this decision approaches, we have met to look back and take a fresh look at this debate. Interest in this conference, both among academicians and legal practitioners, only reaffirms the relevance of the topic of precedent. I am also very pleased that the items on the conference of the agenda will discuss questions referred for a preliminary ruling to the Supreme Court as one of the instruments for harmonizing case law. This is certainly not a mechanism that has been heard and known by every lawyer in Lithuania, and it is natural because there is no such instrument in our legal system. However, at this conference, we will seek to launch the debate as to whether or not such an instrument could be applied in the Lithuanian legal system, or would it be necessary? After all, as Professor Wu noted, we compare legal systems not to find the most interesting or exotic ones, but to improve our own. Finally, precedents and questions referred to for preliminary ruling are not only the mechanisms per se. Lawyers around the world are looking for ways to ensure the case law is consistent. Legal certainty, predictability of the law, and the protection of legitimate expectations are closely interlinked preconditions for the need to unify case law, which help to ensure that the law functions in a stable manner. Therefore, I am glad that an international conference is organized in commemoration of the 30th anniversary of the cassation competence granted to the Supreme Court of Lithuania, gathering representatives of the Supreme Court and the Court of Justice of the EU, as well as academicians from Lithuania and foreign countries who will share their experiences and ideas. On behalf of the Faculty of Law of Vilnius University, I would like to express my gratitude to all those who contributed to the organization of this event, in particular the Seimas of the Republic of Lithuania and the Baltic American Foundation. I wish you fruitful discussions and constructive discussions and all the best in our conference that is going to last for the next for this day and for the next day as well. Thank you. Thank you, Madam Dean. And this concludes our opening part of the conference, which now gives me great pleasure to give the floor for our first opening keynote speech to Professor Habilitus Dr. Burkhard Hess, University of Vienna.
Distinguished Madam
Augščiausia
Nokus, members of the Vilnius faculty, law faculty, distinguished members of the court, advocates, dear colleagues and friends, ladies and gentlemen. It is a great pleasure and an honor indeed for me being here back to Vilnius and to give this keynote today. Oh, I hope it will work. Let me see. Voila. When I started preparing the keynote of today, I was wondering how I should address a topic you are much more familiar than I am. Eventually, I decided to adopt a historical and comparative approach. I will start in the 19th century, when the procedural codes and the Supreme Courts in many Western European jurisdictions were established. Taking up the examples of Germany and Austria, I would like to demonstrate how the courts in both jurisdictions, by procedural and organizational measures, strive to provide uniformity in the application of the law. In the second part of my presentation, I will briefly refer to major changes in the 20th century before addressing contemporary challenges of presenting a coherent case law in the age of digitalization. A little complicated, but it will work. I would like to start with this painting. It is part of a major painting which shows Napoleon. Napoleon becoming emperor of his big French imperium, and he is showing one of his major achievements, which was the Code Napoleon. And indeed, there is a new publication of Dirk Herbaut about codifications, which I can strongly recommend, because Herbaut looks at the situation in several European jurisdictions, like Belgium, the Netherlands, France, and Germany, Austria included, and he compares not only a civil code, but also a commercial code and procedural codes. And this common perspective gives really new insights how codification took place in the 19th century. And there was, of course, one important issue to be dealt with. It was uniformity of the application of the new legislation. And here, the new established courts and the court systems played a fundamental role. They entailed that there was a considerable professionalization of the judiciary and of the bar, too. And the courts also had an additional function in establishing the civil codes, because they also guaranteed constitutional rights. Courts were independent, and therefore fundamental rights like private autonomy, private property, freedom of succession, and fundamental rights in criminal proceedings were guaranteed by independent courts. So this was an important constitutional aspect of the development. So let's look at courts in the 19th century. Let me demonstrate this development by looking at Germany. The building here is a former building of the Reichsgericht in Leipzig. The unification of the Reich, German Reich, in 1817 permitted the adoption of a uniform procedural code and the establishment of the Supreme Court in 1879. And this building in Leipzig was the second most important public building erected during the Imperial Germany. The first most important building was a Reichstag in Berlin, but the second one is this building in Leipzig, and if you haven't been there, I can only recommend to go there, because it is a symbol of the whole German legal system that had been achieved at that moment. But the moment the court started, there was no uniform civil code. There were different civil legislations applicable in the different parts of Germany. And the court during 2 decades did not provide for a unified civil legal system. However, they prepared a little bit this situation by establishing judicial bodies that dealt with the different legal provisions in the different parts of the Reich in a comparative way. So the composition of these bodies was diverse. Judges came from the different parts of Germany and decided on the different regional civil laws. This created a corps of justices able to start in 1900 with a uniform legal system of the code, of the civil code. However, there was one exception. The Prussians, they did not want other justices to step in, and therefore second appeals against violations of the Allgemeines Preußisches Landrecht, the general Prussian law legislation, were only decided by Prussian justices. In 1900, as I said, the German Civil Code entered into force. And at that moment, of course, Section 543, that is a present provision of the German Code of Civil Procedure, became important. And there was a second appeal opened to provide for uniform application of the law. There are specific grounds of admissibility referring directly to the public interest. And according to this provision, you can see it here, the Bundesgerichtshof, the Federal Civil Court today, is only permitted, a second appeal is only permitted if the case raises a legal matter of fundamental significance, transgressing the case at hand, or the further development of the law or the need of uniform adjudication require a decision of the Bundesgerichtshof. At this moment, I should briefly mention a new change in the German procedure of second appeal, which is called the leading decision procedure, to be found today in Section 552b of the German Code of Civil Procedure. This permits the Supreme Federal Civil Court to determine one case raising points of law that are of significance for a multitude of other proceedings. What does this mean? This is a result of the Volkswagen. In the Volkswagen litigation, there were many individual cases collected by platforms, brought to the courts, and then there was a second appeal, and when the second appeal was finished after the hearing, and the court had already given some hints how the judgment might be, Volkswagen settled, in order to avoid any public judgment in the case. And this entailed a lot of frustration within the Supreme Court, and it ended up with this new procedure where the court ex officio in a multitude of similar cases can take up one case, give a ruling, and parties can no longer settle. They can no longer discontinue the case in the Federal Supreme Court. And the day when this new legislation entered into force, the Federal Court already took up the first case, which was a case against Meta, was about scraping. So was about Article 82 of the General Data Protection Regulation, and the court gave a judgment in a very small case, but knowing that there were thousands of parallel cases pending in German courts. So this is, of course, a way of providing for legal certainty and to create a kind of precedent. Also, the ruling of the Federal Court is not binding. Yeah? It has only some authority. Let's now turn to a different court. This is the Austrian Supreme Court, located close to the Ringstraße in Vienna, in an impressive building too. And in the OGH, in the Supreme Court of Austria, there is an interesting mechanism aiming at providing consistency in the case law of the court that I would like now to demonstrate to you. Just look at this photo. You can see all the justices of the Austrian Supreme Court. The number is 60, 42 in civil and 18 in criminal matters. And how to provide for consistency among the different senates, panels of this court. There is a need to have a common knowledge about the case law and the practice of the court. And when this problem arose in the 19th century, you must be aware that the Austrian Supreme Court at that time was a Supreme Court of the Habsburgian Empire. So there were parts of the Balkans, Czechia, Slovakia, northern Italy also included in the jurisdiction of this court, which was even a multilingual court at that time. So this court was established in 1850. And in 1853, there was an explicit duty of the Supreme Court to give reasons that should lead lower instances in the different parts of the Habsburgian Reich. And at that moment, within the court, they created a kind of internal book or registry of decisions, Judikatenbuch, to document the jurisprudence of the court and to create an institutional memory. And this, by the way, also happened in different other courts in Germany, and there is a similar mechanism also in Italy. So, since the 1860s, law journals requested access to this register because they wanted to inform lawyers about the case law. But the court was very much reluctant, stating that this was an internal mechanism, not aimed at informing the broader public. But this changed. In 1872, the emperor consents that judgments of the OGH, of the Supreme Court, could be published, but only with the permission of the court. So this was an official practice of the court of practicing the case law. And in 1885, even in the official journal of the Ministry of Justice, judgments of the court were published. This is not very special, not very much interesting, but let's go to the next slide. But before I do that, I would like to demonstrate to you this recently published book of Julius Schumann. It's a PhD of the University of Vienna, and he, for the first time, really comprehensively looked at the practice of the Austrian Supreme Court in providing so-called Rechtssätze, legal sentences, and I will now take this issue up here. So since 1904, there was a special department of the Supreme Court for the systemic documentation of the case law. The name is Evidenzbüro or Records Office. And it started by phrasing the most important parts of the decisions in a uniform and abstract way. So here we come very close to a system of precedents, which was established by the Supreme Court itself. The senates formulated the sentences. The Evidenzbüro was involved. And in the 1960s, they established a system of index cards comprising the different codifications and laws, article by article. And in the 1960s, this was the most modern way of organizing an administration, providing for index cards. So this was a very small unit within the Austrian Supreme Court, this Evidenzbüro. So it comprised in the 1950s only 4 judges and 2 legal secretaries. But already in 1967, they disposed of 85,000 cards. Per year, they added 5,000 additional cards with sentences, and they also contained references to the legal literature and even parallel decisions of courts in Germany and in Switzerland, and also references to the European Court of Human Rights. By the way, there is a big problem until today. The case law of the European Court of Justice is not in this system, and therefore I would say it's incomplete, I'm afraid. So what happened in the 90s, 70s, 80s, and 90s? The whole system was put online. So they changed to the digital in the mid-1990s. They took up the existing cards. They were 135,000 cards. They could not be copied. They were typed manually by teams into the new system. The system started quite early. It was a rather primitive one, but all of a sudden, the internal memory of the Supreme Court became a source of public reference. And this is quite interesting to see. Also, the way how it was shown was still the old way of the cards system. So, what can we finally say regarding the Austrian legal system? We have a fully accessible database, not only regarding case law, but also legislation, which is organized by the Chancellery of Austria, so it's a federal issue. And it comprises two parts. On the one hand, the legal sentences, the Rechtssätze, I will come back to this and explain this a little further in a moment. And of course, also full text of decisions are online available. And all this is organized by the Obersten Gerichtshof, by the Evidenzbüro. So, as a result, the internal memory of the Supreme Court was made a public source of information. How does this Rechtssätze system function? I would like to demonstrate it by an example. Section 18 of the Jurisdiktionsnorm, this is a law about the competence of justices, but also on the challenges of judges. And here you have a provision you certainly know because you find it in almost every legal system, which says a judge may be challenged because there is sufficient reason to doubt his or her impartiality. This is a legal provision. And now we have a main sentence. Unfortunately, I only have it in German, but you can see Rechtssatz, so legal sentence, which says, as a basic principle, in the interest of the reputation of the judiciary, a strict standard applies when assessing whether bias exists. No surprise. It's a little bit also a universal standard. And then they add additional sentences according to additional case law, which was given to the specific provision of law. And here we have in number 3 and 4 subsidiary principles. And I can tell you, you find under this legal sentence not only the decisions I show here to you, but you find almost 50 different decisions with many specifications of the whole interpretation of the legal provision. So this is how the system is functioning. Usually the Supreme Court refers to legal sentences when quoting case law. So there is really, this is a reference source for the Supreme Court. And when it comes to second appeals, there is always a question, do we have a fundamental question? Do we have diversity in the case law? And then they go to the legal sentences and ask, do we have already a sentence which is helping us? Or do we need to permit the second appeal to review our case law? And I think this is an interesting example demonstrating how the case law of the Austrian Supreme Court is impacting on the legal development. Well, if we look at the situation in Europe today, digitalization has changed the landscape. And databases have become a usual service of Supreme Courts. And I suppose you are well aware and well familiar with this database I'm showing here to you. So these databases are used internally and externally, of course, by the justices and by the lawyers representing the parties in the proceedings. And one has also to say, and must say, that traditional sources of information like commentaries, handbooks, etc., they all have been transformed to the digital. And so today we are in a different area, in a different time. Searching databases has become a main task for jurists, and they have replaced to a large extent other sources of references. This is, for instance, very interesting to look, and I come back to this, to look at the German situation. Germany had never such a system as the Austrians. Yeah? The Rechtssatz system does not exist in Germany. The German courts, nevertheless, also go for some sentences explaining the core of a legal decision. But they are only formulated partially by the courts themselves, the deciding panel. Very often legal journals do this task. They add some additional sentences, and there is no official uniform system of, let's say, precedent or legal sentences in Germany. Well, the 21st century has, of course, switched to digitalization, and you can find a lot of information about courts on different web pages, and this one should be known here too. So if we go to the functions of modern court websites, we can find several main functions. One is a technical aspect. So parties get access to the court and to court files, but court files in the US is quite different from access to court files, for instance, in Germany or Austria. Then they provide for a documentation of the court's case law. These are the databases, but there is an additional function which I would like to highlight here. It's the communication with a larger public. And this communication function has become more and more important. But what we can see at the same time is that legal provisions dealing with the task of communicating with the public are very often missing in the codes on the organization of the courts, because this is an ongoing development and lawmaking is very often lacking behind. So we have very modern and interesting web pages of courts. Here we are in the UK, the UK Supreme Court, and they permit also to follow hearings, yeah, to communicate and to demonstrate what is going on. And if we look at the contents of the web pages, you can see that we have now even more. We have, apart from searchable databases, a live stream of hearings, explanatory videos of cases. Even court TV is available. I learned that in the European Court of Justice, a court TV system is on the making. You can look at the calendar of the court, but what I would like to stress here, and this is my last point, are annual reports. Annual reports of courts have become a very interesting means to highlight important cases of the courts. And here you can see the example of the annual report of the German Federal Constitutional Court. And in 2021, the court gave a very important, a landmark decision on climate change. And this decision was explained quite largely, but also in an understandable language to the larger public in the annual report. And the annual report, of course, is available at the webpage of the court. And the same applies to the European Court of Justice. If you look at the webpage of the European Court of Justice, you can find yearly selections of major judgments. This is really the court saying we had some important decisions and we would to highlight them and we would like to explain them to the public by this yearly selection. Then you have the annual report, and YouTube, etc., is also present there. Maybe this is a little bit a reaction of the situation of the European Court of Justice, which has become less accessible for the public, because there have been some manifestations in Luxembourg which were, let's say, nasty. And so there are more and more controls, as we have experienced them this morning here in this building too. And in order to improve accessibility online, you have these web pages which help to explain and to understand the case law of the courts. This was my keynote for this morning. I wish you a very successful conference and very interesting debates these days. Thank you very much.
Thank you. Thank you very much, Professor. Dėkojame profesoriui Burkhard Hess ir man.
Thank you, Professor Hess. This completes the end of the first part of our conference on the building, or perhaps some would disagree, not building, of a precedent. And now it gives me great pleasure to invite Professor Dr. Margaret Wu from Northeastern University School of Law for her keynote address.
Just press that? Yes. Okay, great. Thank you so much. I want to first begin by congratulating the court on its 30th year anniversary of its secession authority. I got it. It's fine. And 30 years mark a generation. But given today's rapid developments, I think it's more than a generation of change and evolution. I also want, in addition to congratulating the court on its anniversary, I'd like to thank the court and the faculty at Vilnius University, particularly Professor Vibre, for the invitation to speak on today's important topic. And that is that of ensuring uniformity in the application of law. Because every legal system needs some guidance in ensuring uniformity in the application of law, particularly given today's propensity for lightning change. Now, there is an old joke here I wanted to show you. And the old joke is one man asks another, what's the difference between God and a judge? And the other man says, well, God doesn't think he's a judge. And the implication is, of course, that a judge incorrectly thinks he or she is a god. Because a judge is not a god. Judges are supposed to be impartial and must make decisions that are not based on their own personal or policy preferences. They must decide based on legal rules and codes, and in common law countries, also according to precedents set by the courts. But today, the premise of judicial impartiality is challenged globally. And I say, in particular, in today's hyper-politicized United States. We see efforts to destroy the public's trust in the court's impartiality and weaken the judicial branch that's so fundamental to the idea of checks and balances inherent in democracy and the rule of law. And so this conference is critical and timely. How do we protect judicial impartiality? And in a common law system, adherence to precedent is critical to judicial impartiality. But not only is adherence to judicial precedent important for consistency, as we all know, interpretations of law vary from person to person, judge to judge. But adherence to judicial precedent, particularly if the precedent is binding on the judge, is one of the most important ways to protect judges from improper outside influence. So I will address this topic in 3 parts today. First, what constitutes adherence to precedents? Second, why, very quickly, is precedence so important? And third, really most important, when do we turn away from precedent? When should precedents be overturned? Okay. So as to the first question, why is, let me see, it's not changing. Let's see.
Go to next.
I did go to next. It's not moving. Here? Oh, so I should use this. Okay. So, what is adherence to precedent? Well, adherence to precedent is very fundamentally a principle whereby past court decisions serve as the basis for deciding similar cases in the future. And this principle promotes consistency, predictability, and the application of law by requiring courts to follow legal decisions made in earlier cases. Because as we said earlier, human beings can vary in their interpretation of law. And so adherence to precedent is necessary for consistency. There's a spectrum of what constitutes precedents. In the common law world, precedent is intertwined with the sister principle stare decisis, which means to stand by things decided. And in that instance, not only is the precedent acting as a model, but under stare decisis, precedence becomes law. It's really a legal principle or rule that is binding, mandates, right, adherence to the decision. So under stare decisis, precedents are themselves, if they apply, are binding and then themselves are considered law. And I think almost all, actually, legal systems have some kind of practice of recognizing judicial precedents. What varies is how binding they are, right? So as I said earlier, the US has a very strict binding common law system. If the case applies, it's binding. But other systems, like the civil law system, by contrast, would utilize precedent more as guidance, persuasive authority. And in the US, if a case is not binding because it doesn't, in the hierarchical model, the decision doesn't fall within kind of the authority of the court that issues it, then that precedent can also be persuasive. So in the common law system, you can have binding or persuasive. In many civil law systems, is primarily persuasive. And even the Chinese legal system, a relatively new system, has what they call a guiding case law system, under which the Supreme Court will selectively publish certain legal opinions which it intends to be broadly applied. And under the Chinese guiding case system, a guiding case is published by the Supreme Court, and they are binding, but they're not considered law. So it's somehow in the middle. And in in China, in the People's Republic of China, for example, right, this guiding system is relatively limited. It's only a limited number of written opinions. In the Chinese system from 2011 to the end of 2018, the Supreme People's Court released only 106 guiding cases in total. and it varies from year to year. But on the average, only 12 cases were released in the past 8 years, right? So these lower numbers, right, certainly eases the need for judges both to train in writing opinion and the need for a reporting system, and I'll get to that. So again, where the president sits on the spectrum from binding to persuasive, as well as whether the president is broad or narrow, depends on the country's legal system. But regardless of whether presidents are considered binding, persuasive, or guiding, as in the Chinese system, the same policy underlies adherence to precedent, and that is, of course, the need for even-handed, predictable, and consistent legal principle. And this predictability is not merely a convenience, but it is necessary for a functioning society where individuals, businesses, institutions need to be able to understand what the law requires and plan their conduct accordingly. So too, why is adherence to precedent necessary? And some of what I describe will go into what it takes to create a precedent system. So adherence to precedent really ensures, as you heard earlier, uniformity and predictability. And again, given the variety of human interpretations, judicial decisions can be unpredictable and subject to personal bias. And so without guidance from prior cases, judges will inevitably reach different outcomes in similar cases with similar facts. In a legal system in which there are different outcomes in different cases, or different outcomes in similar cases with similar facts, would be functionally limited. Such a system can only decide disputes one case at a time and punish a citizen's misconduct retroactively. Because a citizen, without this idea of precedence or knowing what was decided beforehand, cannot prospectively anticipate and understand the law and plan his or her conduct accordingly. And so without uniformity and consistency, then a legal system lacks legitimacy, and it is difficult to respect and obey a legal system if decisions are viewed as arbitrary. That is, again, if similar cases receive different treatment. Public confidence in the courts really depends not just on fair outcome, but on the perception that the system operates according to consistent principles. A legal system loses legitimacy if people cannot rely on the consistent application of legal principles over time. So what this tells you also is what a system, a legal system, requires of precedent. I still can't. Is it next? Yeah, okay, thank you. I did, but it didn't, okay. So again, what you really, for a system of precedent, because you do want it to be a source of guidance, not only to judges, but to the public, then you really need clearly written opinions that are setting forth the rationale for decisions. And that these opinions are published and easily accessible to the public, right? And that means then, and that the scope of authority of the judicial precedent must be clearly understood. Because what you're educating is not just judges, but the general public as well, and the parties, potential parties before the court, and the lawyers who might appear before the court. So the system of easily accessible published opinion is not easy to develop. As we saw for the Austrian system, it took several hundred years to develop that. What you have really is, it requires judges well-versed in writing opinion and outlining the rationale. And at the very least, in the common law system, this begins in law school, requiring lawyers or law students to center and train on the study of judicial opinion, right? And what this system of precedent also require is, again, not only good legal training on understanding how to read and write opinions, but also a system that could report these cases and make it easily accessible. And again, in the Chinese system, we see that it's a public system, opinions issued by the Supreme Court, and easily accessible. If you go on the Supreme Court webpage, I see it for the German and Austrian Supreme Court. But if you have a lot of precedents, that is not simply the Supreme Court, but if even you're trying to use lower court opinions as precedents, then you might need what we have in the US, which is a private reporting, case reporting system. That is, I have one of my students here now. Very first thing you learn in the first year of law school is how to use this case reporting system, the Westlaw, Lexis, and this reporting system will compile thousands and millions of judicial opinions into categories in order for you and judges, lawyers to find it. So you do need a very, very elaborate case law reporting system. Third, this also usually means that you need a hierarchical court system. That is, if judicial precedents are going to be binding, then you need to know who is it binding on, right? And so one of the very first things that law students learn in reading these judicial decisions is to understand which court's opinion is binding on which lower court. And this will separate out judicial precedents that are binding from judicial precedents that are merely persuasive authority. So again, the third thing you really need is an understanding of an hierarchical kind of court system by which each judicial decision issued by that court, the authority, the bindingness of that is clearly understood. Let me see. I really am pressing. You might have to stand next to me all this time. No, that's fine. Okay. But most importantly, you think this is better? Okay. Okay. But most importantly, the question is, when should precedents be overturned? Now that you've got a system all set up, you understand why it's important, and we want a system that's, easily accessible and transparent, but society changes and precedents need to change. So when is it appropriate for an important decision to change? So consistency, of course, is important, but not necessarily set in stone. And how does then a legal system balance the need to maintain stability and consistency with ensuring that law can evolve and correct clear mistakes. And overturning precedents cannot be taken lightly. I am going to describe and discuss what the US Supreme Court has said about when to overturn precedents in the hopes that this discussion is informative. So in the 250-year history of the US Supreme Court, only about 235 decisions out of over 30,000 US Supreme Court decisions have overturned prior precedents, right? And among the most famous are really two decisions that I'm going to talk about and how the courts, in overturning these two decisions, treat precedents slightly differently, okay? One of the most famous, and you might have heard of this Supreme Court decision, is the 1954 decision in Brown versus Board of Education, which overturned the 1896 decision in Plessy versus Ferguson. And the decision essentially establishes the importance of equal protection in education. Plessy had originally established a principle of separate but equal to hold that racial separation, segregation in public school is appropriate. So Brown, finally in 1954, challenged that separate but equal to overturn that Plessy decision to say that separate is not equal. So it's a very important decision. The second decision I will talk about is the Dobbs decision. And this is the most recent decision, and you might have even heard about it here in Europe. But the Dobbs decision essentially deals with a woman's right to an abortion. And Dobbs versus Jackson Women's City Health overturned Roe v. Wade. And Roe v. Wade was a 1973 Supreme Court decision that essentially guaranteed a woman's right to obtain an abortion. And it has been a principle that has been reaffirmed repeatedly since 1973, right? So both Brown versus Board of Education and the Dobbs versus Jackson Women's Health overturn important precedents, important or fundamental rights, right? And so how did they do that? This is what this works. So in the US, the Supreme Court has previously articulated a test for when you should overturn a legal precedent. And in Planned Parenthood versus Casey, the Supreme Court repeated a four-factor test. One, the question is, if you're considering Supreme Court overturning a principle or a precedent, you have to consider, one, whether the prior precedent has proven unworkable, the question of whether it can be understood and applied in a consistent and predictable manner. If that precedent hasn't done that job, then it might be worthy to consider overturning it. Second, to what extent have citizens relied on the precedent? Because if citizens out there know about this precedent and have relied on it and have planned the conduct accordingly, overturning it is a big deal, right? It's really problematic. Third, the question is whether related legal principles have developed in other areas of law that leave the old rule as remnant of an abandoned doctrine. That's a mouthful. It only simply means whether this is now outdated and that other legal principles, right, have developed in other areas of law that has left this old principle behind. Right? So, fourth question, whether the facts have changed so as to rob the old rule of significant application or justification. All right. So is this old rule now inapplicable in today's changing facts? So all these 4 criteria should be considered before considering or overturning a precedent, okay? And of all these factors, of all these 4 questions that courts consider when evaluating whether to overturn precedent, the Supreme Court has emphasized reliance. That has proven to be often the most difficult and deserves the most attention. That is, this precedent has been out there for 30 years now. How much reliance has been placed on it such that turning away from it is going to present a problem? And reliance lies really at the heart of any system of adherence to precedent, any precedent system. And when the Supreme Court considers overturning precedent, it must weigh whether and to what extent individuals have relied on that precedent in ordering their affairs, right? And the court has consistently identified reliance interests as a central consideration on whether or not to overrule precedent. But the Supreme Court has never developed a systematic methodology for weighing reliance as to the other factors in this consideration. So how does it, how is reliance in considering this weigh in terms of whether the precedent has proved unworkable or whether related principles have developed? How do you balance that? Well, I point out to you something written by former Supreme Court Justice Goldberg. And he wrote in his book, Equal Justice, the Warren Era of the Supreme Court, articulated this principle, and it's called the uneven force principle. And the idea is that this principle should inform when one can overturn precedents and deviate from stare decisis. And what Justice Goldberg observed was that when the Supreme Court seeks to overturn a precedent, in order to cut back an individual's fundamental rights against government interference, then the command of stare decisis is all but resolute. So when you're cutting back on fundamental rights, Justice Goldberg says, then that precedent, it'd be harder to overturn that precedent. When a court seeks to overrule by expanding personal liberties, okay, then the doctrine interposes a markedly less restrictive precedent. So in other words, when you're seeking to overturn the prior precedent, and if the new case is seeking to restrict the prior precedent's guarantee of constitutional right, then we need to be more cautious. But if the new case in overturning the prior precedent, right, is actually expanding fundamental rights of the individual against a government, then maybe we could be less cautious. And that's essentially the principle. So let's see how it works in these cases. So if you look at the Brown versus Board of Education case, the court was expanding the right of racial minorities in that case, again, it was a case challenging the concept of school segregation. In the US, prior to the Brown versus Board of Education, you could have schools that were deemed as being separate but equal. One school for blacks and one school for whites. And in prior to the Brown Board of Education, that was considered to be fine. Right? Board of Education, the Brown versus Board of Education challenges that. And so, and in challenging it, it's actually expanding the rights of blacks to equal education. And so in that decision, if you look at that decision, despite the existence of arguably significant reliance interests on the prior precedent, right, the opinion was very short. Most of the time, the opinion was dealing with focusing on the prior precedent's erroneous understanding of the 14th Amendment. You could argue there were substantial reliance interests based on the prior Plessy decision. That is, there were schools had planned their system according to the prior Plessy decision of separate but equal. So if you want to focus on reliance, you can make a very strong argument that reliance would not justify overturning Plessy with Brown. But however, in that case, in Brown, the Supreme Court implicitly rejected these reliance interests without substantial analysis of these interests and focused almost entirely on the whole idea of Plessy's erroneous understanding of the 14th Amendment and the harm of a segregation, right? And if you look at the next decision, Dobbs, it presents a case, again, where the court ultimately ruled in a 6-3 decision to retract previously recognized constitutional liberties. In this instance, Dobbs was retracting the idea that a woman has a constitutional right to an abortion. And again, then under this Justice Goldberg's uneven principle as to when to overturn precedents, then you would have to deal with the reliance interests a little more carefully because you are retracting rights. And when you are retracting rights, you need to be more cautious. And so again, Dobbs, in this instance, involved a challenge to a Mississippi law banning abortion after 15 weeks of pregnancy. And again, it is retracting a previously granted constitutional right. And so the majority wrote an extensive opinion and essentially had to dismiss 3 types of reliance interests. First, the majority addressed the idea of concrete interests pertaining as to whether individuals had actually made specific decisions about pregnancy in reliance on Roe v. Wade, the prior decision. And the court essentially says, no, but that's less important. Second, the court considered and then rejected as intangible other forms of reliance interest, including a woman's ability to participate equally in economic and social life, right? The idea that the pregnancy is so much tied to a woman's right to participate in social and economic right. So the court had to address that kind of reliance interest. Finally, the court considered societal reliance and development of social arrangements based on abortion access. And that is, again, has society have some kind of interest reliance interests based on this idea of a woman's right to abortion, and concluding that American society was adaptable enough to adjust to the elimination of this constitutional right to abortion. So you can see how the Goldberg principle in this instance operated. It required, at the very least, the Dobbs decision to be explained in extensive detail. It's just much more cautious. Now, laying aside the disagreement about the correctness of these decisions, right, one can see the detailed dismantling of reliance arguments in Dobbs is very different from Brown, the Board of Education, that was expanding rights to education to racial minorities. And the Dobbs majority could not simply declare Roe, the prior decision, Roe v. Wade, erroneous without addressing the nearly 50 years of reliance that had developed. So unlike liberty expansion, liberty restriction inherently raises questions about disrupting established expectations that must be addressed. And when taking away recognized rights, the court, let's see here, the court must face a heightened burden to justify reliance interests should be overturned. And it is a burden, right, that is less burdensome or less onerous when you're considering overturning decisions to expand rights. Now, critics, however, cannot, let's see here. And so critics, of course, of the current Supreme Court have suggested that Dobbs overturned not only Roe, but even the whole established framework for when to overturn precedents. And critics have actually argued that Dobbs itself improperly rejected the precedent framework set out in the prior case, Casey, by reinterpreting what constitutes reliance and by giving less weight to intangible reliance interests, all right, and greater weight to the factor of egregious error. And they essentially, critics of the Dobbs opinion, essentially pointed to well-known views of certain justices on the Supreme Court, like Thomas Gorsuch, who have actually questioned the value of stare decisis. So critics of the Dobbs opinion would say that Dobbs is not just illustrating Goldberg's uneven principle at work, but rather it's just purely political. That is, that the Dobbs decision actually overturned the whole test itself by focusing, by reinterpreting what constitutes reliance, and by pointing at the presence of certain Supreme Court who have questioned the value of stare decisis. So even with very carefully outlined judicial opinions and rationale and four-factor test for overturning precedents, there is still disagreement as to precedents and when to overturn precedents. We do the best we can, but it's still a controversial one that is evolving. So, in conclusion, the more difficult question really is when to overturn precedent. How to set up precedent is difficult, but it's almost mechanical. And again, as you heard from Professor Hess, with today's digitization, it's very easy to set up these decisions and have it easily kind of search and apply and to be able to be found. But the more difficult decision is when you overturn these precedents. And to consider that, I would still urge the consideration of Justice Goldberg's uneven principle. That is, when you expand fundamental rights then you could be a little less strict in adhering to prior unjust principles. But if you are contracting fundamental rights, then you might want to be a little more careful and require more thinking and more justification. It is certainly clear that overturning precedents may at times be inevitable, but to easily overturn precedent will undermine the policy reasons why we follow precedent and perhaps it themselves, and may even undermine democracy itself, since it would take away the very important checks on judicial independence. So the lessons from the US is cautionary. I hope it's instructive, and it's cautionary in urging that you do need to overturn, but that, again, it may be problematic if it's too easily overturned. And I just want to thank you for your attention, and I don't know how to speak Lithuanian, but I do want to express my thanks.
Thank you so much, Professor. And now we'd like to invite everyone for a coffee break, which will take place in cafeteria next to the main hall. Norime visus pakviesti kavos.
I would like to invite everyone for a coffee break, which will take 23 minutes.
Sveiki sugrįžę iš.
Welcome back after the coffee break. We're still at the first part of the conference, which will include 4 presentations and discussion, during which you'll be able to ask questions about the presentations that you've already heard. I am Eglė Zemlytė, Judge of the Supreme Court and Professor of the Faculty of Law at Vilnius University. I will be moderating this part of the conference. I would also like to highlight that the question time is scheduled at after the speeches. I have 4 speakers on the stage. This is Professor Valentinas Mikelėnas. He's going to talk about the president in the Lithuanian legal system, whether it's an illusion or a reality. I wonder if we're going to be criticized or praised. Then Professor Egidijus Kūris is going to talk about precedent in Lithuanian constitutional doctrine. Also, we have Professor Remy Verkerk from Utrecht University, and he's going to talk about the absence of precedent in the civil law tradition. And finally, we're going to hear from Dr. Rimvydas Norkus, Advocate General at the Court of Justice of the European Union. He's going to talk about whether the Court of Justice of the European Union is a court of precedent. So without further ado, I would like to give the floor to Professor Mikelėnas.
Good morning, ladies and gentlemen. In general, precedent is a good thing because it means that we're all learning from what was back in the past. If we don't do that, then we behave foolishly. The same could be said about a judicial precedent. If a justice fails to find an answer to a legal dilemma, he or she can look back into the legal practice, legal case law. Without that, well, first of all, judges rely on the previous case law simply because it's quite logical to make use of something that has already been tried in the very same situation. It's convenient. And if we have a hierarchical judicial system, a judge who is unable to follow the practices of higher courts, he or she might find it difficult to move along the professional career lines. So our practice, our judicial practice is considered universal, uniform, and in the UK, stare decisis principle was followed since 1865, so it has been in place for many years. And in the meantime, we have undertaken a precedent system following the re-establishment of our independence. So we're quite fresh in applying the system. Now, if I were to ask you what a precedent is, I believe you would be able to tell me that it's a previous court decision adopted in a previous case by a court, based on which a court nowadays will rule in reliance on the previous decision. But that would be a faulty answer to my question. This would mean that any court can rule in a case by relying on a civil code. We would say that this would not be a reasoned ruling, a reasoned decision, because in a civil code, we would need to find a particular legal rule regulating this kind of factual situation of ours, which means that a precedent per se is not a ruling of a court. It's just part of a court decision which gives the reasoning, outlining the legal rule that we would be invoking. Without that kind of legal rule, the decision would be quite different. In other words, a precedent is something that cannot yield a result. That without it, we cannot yield a result. But how do we learn where to find a particular legal rule? Well, lawyers are involved in delivering long decisions, certainly to be able to get a higher payment from their clients, but I'm not sure why judges do that, because their decisions last for up to 150 and beyond points. Professor has said that their courts take just a few sentences to invoke them in their cases in making rulings. Well, you could criticize me in saying that the Code on Civil Process maintains a provision claiming that the Supreme Court, in its ruling, in its decision, must give a reasoning for applying its decision. But this goes only for the Supreme Court and not the Appellate Court. Okay. Just to entertain you, yesterday I looked up on the Infolex for some keywords, and the results they've given me were as follows. In the period between 2021 to 2025, Infolex gave me the court rulings, court decisions, a number of them. Guess the number of it. Well, 96 court decisions were given to me in my query. When the courts fail to deliver the rule that they have come up in their decision, we are faced with a dilemma. Well, the British have a few standards. Which ones do you apply? Gotthard or Humboldt criteria? Well, perhaps we have a Lithuanian criterion applied since 2008. So in a case when the court fails to give a reasoning, this means that judges who will analyze the decision made will be able to say this is that there are ratio decidente, and the other judges might say that there might be quite different reasonings in this court. I was given another question, whether a judge of a lower instance can disagree with a judge of the Supreme Court or challenge that the judge. Well, if he says that this is if the decision is not binding, this means that you can come up with a different decision. So unless we have an effective precedent system, unless we are aware of the rules, how to decode the decisions, we won't have an effective precedent system. Professor Hess has also talked about reporting. Well, if precedent is binding, it's already part of law. Fuller once said that this could be considered a law. We say that unless it is announced, it is not to be considered a law. But if we have to formulate a system so that judges, lawyers, and ordinary people are able to keep track of those legal decisions, then we must have a system that is accessible. If our precedents, however, are not systematized or made publicly available, how can we expect from these people to follow or abide by the rules made by courts? Well, Professor Wu mentioned the quality of decisions. Out of 96 court rulings that I was given in my query, I looked into the legal rules that have been shaped in those decisions. Let me give you an example from the case in 2020. The law on public procurement is lexis specialis. Is this to be considered a rule? Is this going to be considered a precedent? After all, the Civil Code maintains that the specificities of public procurement are to be outlined by a dedicated law. So are all decisions by a Supreme Court to be considered a precedent? The answer is no. Unless a new rule is formulated. Certainly, the Supreme Court has adopted quite a few important precedents. For instance, the Civil Code establishes a closed list of persons that are not to be subject to be granted compensation for loss. and a new norm, a new rule that supplements the civil code was formulated by the Supreme Court when it ruled that the close ones or relatives of a victim are also entitled to a compensation. But it has been said that judges are not gods, but you know, once you try, you can't stop, there's a saying. So whenever you're able to formulate one legal rule, you're always tempted to come up with another and another and another one. And so the Court of Appeals has been quite strong in saying that the law on the rights of patients in delivering on what is to be considered as non-pecuniary or pecuniary loss does not bind the court. So can you imagine the situation this kind of rule creates? The court failed to understand that when it comes to this particular field, the legislative made sure that the court is not bound by the provisions of the law, which means that the social fund can soon run out of funds because of the cases that might be lost on the basis of those provisions of the law. But the courts have to follow a kind of reasoning that do not cause any social frictions. Yet another dilemma that has not been touched upon today is the retroactive effect of precedents. Imagine you are creating a new rule in a current case, and you apply that rule to the events that happened some 3 or maybe 10 years ago. So can you imagine the kind of shock that this kind of ruling creates? And you can only imagine what kind of repercussions this might have in the future cases that will rely on the decisions that you'll be making today. There's an interesting case in France when a doctor was made liable for the actions he conducted back in 1974, simply because in 1998 the Court of Cassation in France formulated a new rule. So just think about that situation and how we should go about it. And my last point. Certainly, an effective precedent system cannot be established by courts alone. Then other preconditions must also exist. And so we should start from law schools and the education system. I'll take a look at the situation in the US or in the UK. The first-year students of law schools, they start their studies from getting into the law reports and analyzing them. We will not be able to establish an effective system without a different approach from the bar and from proper skills of the people involved in delivering court opinions. Just take a look at the opinions that are quite lengthy but have nothing to do with the cases that are being ruled on. So that would be it on my part. Thank you for your attention.
Tai jau kalbėti ir be...
Taip.
Ačiū labai.
Taupau laiką.
Ačiū gerbiami.
Thank you. It's very nice to see you all here after the summer. I would like to thank Egle for creating a precedent Valentinas was allowed to go over time, so I'll try to use this precedent as well. I'm going to talk about precedent in Lithuanian constitutional doctrine, and I will start by quoting a strange statement made 3 years ago in the plenary chamber of the Seimas by a candidate judge to the Supreme Court. He said that the recognition of judicial precedents as a source of law in Lithuania meant that Lithuania had become a common law state. This, may I say, instance miscommunication shows that sometimes even established lawyers do not know what common law is and what historical and cultural conditions are needed for the development of this law, and that it does not appear simply because a court, in this case the Constitutional Court, in its rulings assigns a few paragraphs to a source of law such a court precedents. It can also be seen that some did not fully understand the ruling of the court, and they think that precedent was constitutionalized in the sense that it was officially inscribed into constitutional doctrine and through it into the constitution, rather than clarifying that its power as a source of law already derives from the constitutions, from the rule of law, the principles of justice and equality of persons. Now that ruling is regarded as a landmark, and it was so extraordinary that a conference was even held to mark its 10th anniversary in Vilnius University. And at the beginning of the conference, the then presidents of the Supreme Court said, and I quote, "The judicial precedence in Lithuania has risen de jure to the level of the official source of law, has undoubtedly shaken the Lithuanian legal community." The word official is clearly excessive here because there are no unofficial sources of law, but I would like to draw your attention to the word shaken, even though the president soon said that the shock had passed. But what that shock actually means, it can be understood as either descriptive or normative. As a descriptive statement, it is correct. In this respect, lawyers experience a certain shock, and in this respect, they resembled seismologists dozing off at their equipment and failing to notice the obvious signs predicting a volcanic eruption. And when the volcano finally erupts, they feel caught off guard. Although the signs had been there, although before that the Constitutional Court did not have to deal with a case in which it would have been necessary to formulate the broader doctrine of judicial precedent. In that case, however, such a need arose. It examined, at the request of an administrative court, whether a provision of the law on the Constitutional Court, according to which the annulment of a certain legal act is the basis for the decision of that court to terminate the legal proceedings instituted, was compatible with the Constitution. In fact, the court had already clarified this in this ruling, but it did so on an ad hoc basis, explaining why the proceedings had not been discontinued in that case. Because the government, hoping that the proceedings would be discontinued, amended the contested resolution 4 days before the hearing of the court. In 2006, however, the main issue was the continuity of the case law of the Constitutional Court and other courts as an integral part of the constitutional concept of the administration of justice. In this context, the court had to explain the significance of the precedent in the Lithuanian legal system. Let me remind you, the case was one of the many cases where judges were litigating about their salaries being reduced. Unfortunately, Lithuanians' jurisprudence on this issue is probably the richest in the world. The first one of those cases was resolved by the infamous ruling of the 12th of July 2001. In the ruling, the court terminated the investigation into the constitutionality of 3 acts, although the case had been initiated by as many as 11 courts. This is what the administrative court
prikišamai parodė tą bylą inicijavęs kad Konstitucinis teismas pats nesilaikė savo precedentų ir savo suformuluotos doktrinos, bet to ta doktrina buvo tik pernai suformuluota, o Konstitucinis teismas nuo jos nukrypo. Bet jeigu kas tame 6 metų nutarime tikrai galėjo būti netikėta teisininkų, taip sukrėsti, bet pačia geriausia šito žodžio.
So the legal community was shaken.
Aš kankinu vertėjus, žinau, atsiprašau, gerai, tada. Taip, tai, kad Konstitucinis teismas parašė ten vieną kitą pastraipą.
Constitutional Court has written a paragraph or two about precedents, but it openly acknowledged the inconsistency of its previous practice. And this is a rare case both in Lithuania and worldwide because such instances of self-criticism are rare. Was it possible to avoid the passages referring to judicial precedents in that ruling? Of course it was, but then the ruling would have been much less persuasive and the Constitutional Court would have appeared to be avoiding an unpleasant issue. The court soon had to deal with another case in which the issue of the relevance of judicial precedents was raised quite directly. That case was initiated by a court of general jurisdiction which had doubts as to whether the provision of the Code of Civil Procedure was that the courts, when applying the law, take into account the interpretation of the application of the law contained in the cassation orders was too narrow. The Constitutional Court criticized the provision as poorly worded, but not unconstitutional because it did not prevent courts from taking into account both the interpretations of the application of the law, which are of unprecedented importance for a given court in a similar case, and their own practice of applying the law. It emphasized that precedents must be used with extreme cautions, and that every precedent and deviating from existing precedents should be well argued. There are certain rules of collision of precedents, and those who read it carefully, they could have noticed that there was nothing new in that ruling. The more attentive readers may have noticed a few sentences that were borrowed from the book written by Mikelėnas in 1999. But those who read it carefully were not plenty. But I haven't noticed anyone mentioning or writing about this anywhere, because in order to criticize that decision, one needs to read books and doctrines. In 2006 and 2007, there was nothing new said. Although it was laid out in a systematic way. Since 1991, such statements have been found in rulings of the Supreme Court, and this is the equivalent of the idea of jurisprudence constant. In 2004, the Constitutional Court stated that the discretion of the courts was limited. In 2003, the Constitutional Court clarified that its own acts are sources of law. So there were hints And in that case, they were systematized, the doctrine was elaborated, and that uniform judicial practice requires the use of precedent.
Nors žemesni teismai yra saistomi aukštesnės instancijos teismų sprendimų, tačiau
It's stated that lower courts are bound by the decisions by higher courts, but judicial practices are formed when courts themselves decide cases.
jeigu mes pažiūrėsime į kitų teismų praktiką, na gerai, Europos žmogaus teisų teismų praktiką.
Let's look at the judicial practice of the European Court of Human Rights. This court relies on its previous decisions.
Pagal vieną straipsnį, nežinau, toks konspektyvus 150 puslapių tekstas, bet niekur jais nesiremiama, remiamasi bylomis, tai čia yra pagalbinė medžiaga, kuri yra reikalinga.
So those cases is a very important material. And as for the advisory opinion, they don't have they're not obligatory.
Jomis pats remiasi, dėl to natūralu, kad ir nacionalinis teismas, kuris tos išvados paprašė, jisai turėtų.
Of course, this opinion is only formal, as the court subsequently relies on the interpretations of the convention provisions provided in the advisory opinions. But let's come back to the Constitutional Court. There are no hints that judicial precedents could replace statutory law.
Darydamas atitinkamus įstatymų pakeitimus.
These rulings revolve around the idea that precedent does not replace the law, but rather explains it.
Tam tikra prasme ir atsakymas tiems kultūros karų dalyviams Seime, kurie, pavyzdžiui, labai dabar rūpinasi, kad teismai nepriiminėtų jokių.
And this is the answer to those people in the Seimas who do not want to work on civil partnership law here in the Lithuanian Seimas.
20 mečių senumo doktrina, kadangi doktrina yra tokia, kad jeigu nors šiaip jau statutinės teisės pataisos gali įveikti precedentus į ateitį, bet visas
Constitutional courts
jeigu Seimas, kaip štai partnerystės atveju, užsima tokiu dalyku, nu, absurdiškai skamba, bet aš sakyčiau, labai yra užsiėmęs neveikti.
Seimas, as absurd as it may sound, is engaging in inaction, so the courts have to fill in those gaps in law, and courts engage into that. But there's also room for legislators to improve legal framework, and that those amendments must comply with the constitutions, and whether they do comply is examined by the Constitutional Court.
Reiškia, baigdamas šiek tiek trumpindamas vieną dalyką, taip, visiškai trumpindamas. Precedentais teismų praktikoje čia aš galiu antrinti Valentinui Mikelėnui.
I'll agree with Mikelėnas. Precedents are all very often used superficially. There are several quotes from rulings of other courts. Those quotes are not related to the case, but they look as if they had been relying on practices of other courts. I had written about it in the past, but the reality is far from ideal. But we need still to work on that. In 2006, we were joking that we have a program for 50 years to create an accessible system, and 20 years have passed and we still don't have that system. But the problem is inability to use precedents properly, to use this tool properly. And finally, since I'm running out of time, there are certain issues related to the Constitutional Court being bound by precedents. Unfortunately, there are examples of the Constitutional Court deviating from its own precedents without justifying it. Maybe we're going to talk about it during the discussions.
Okay, so please, Professor Ferg. You can just...
Esteemed participants, thank you for inviting me here at this conference. It's an honor to be here, and as this is a very prestigious event, it is only appropriate to address an overly ambitious theme, being precedent in the civil law tradition. Being utterly ignorant of most civil law jurisdictions, I am afraid I will not meet your expectations. I do hope to make some general comments on the rich history of precedent on the European continent. I will speak slowly for translation purposes, as I understand exceeding one's time now is standing precedent. My contribution will discuss two seemingly conflicting strands of thought that have resurfaced throughout history. And the first strand is that a principle of precedent, or some system of precedent, is both rational and inevitable. The oldest Supreme Court in Europe is the Sacra Rota Romana. Various doctors in canon law and members of the court started writing texts discussing decisions of the court that were rendered throughout the 14th century. These materials were later combined and printed under the title Decisiones Rotae Novae et Antiquae. Copies of the book were reprinted many times and ended up in the libraries of all major courts, such as the Parlement de Paris and the Reichskammergericht. I understand a very early copy is also available in the Vilnius University Library. The Rota's case law was very authoritative and contributed greatly to the emergence of a jus commune on the European continent. The book also stood at the beginning of what one could indicate as a new legal genre. From the 14th century onwards, more than 400 similar books that discussed case law of different courts throughout the continent were published. Writing such law reports during the Ancien regime was a bit of a challenge because judges did not always reason their decisions. Nevertheless, and despite these challenges, many of these books were published, and they more or less are similar to the law reports we still use today. The uncoordinated emergence of a massive body of case law was rational, particularly so, as also emphasized by some of the other speakers, within professional hierarchical court structures such as that of the Catholic Church. Higher courts are inherently concerned with values that have been stressed today, such as uniformity, legal certainty, and equal treatment of all under the law. Lower courts also had good reasons to follow precedent, as discussed today, if only because it concerns their salaries or to avoid that their careers be limited. Lawyers, no doubt, had the strongest incentive to be concerned with case law, and they have certainly promoted its use in early medieval times. After all, what lawyer could possibly resist the temptation of reminding a court of a favorable judgment rendered before? some authoritarian leaders have tried to suppress the use of case law. Emperor Justinian, for example, dictated, and it's a much quoted text, the decisions of courts should not be founded upon the examples set by others, but upon the laws. If the law was unclear, he just requested judges to ask him for clarification. He abolished the rule 15 years later, as requests for clarification were numerous and had led to significant court delay. Emperor Joseph II of Austria codified and unified procedural law in large parts of the present-day Austria, Hungary, Italy, Croatia, and Slovenia. The 1781 Allgemeine Gerichtsordnung emphasized that all judges had to stick strictly to the ordinary meaning of words in the code. Well, this led to a lot of problems, and the rule was much criticized and later retracted. The new statutes clarified that judges, if they could not decide a case based on the words in the statute, they could decide the case based on similar matters that were properly regulated, or they could consider the general principles and objectives of the code, thus showing that judges have wide powers to interpret statutes. Another example, Frederick William II of Prussia introduced the Allgemeines Landrecht für die preußische Staaten, already mentioned by Professor Hess. It was implemented in parts of present-day Germany, Poland, and I understand also in small parts of Lithuania. Article 6 of the Code explicitly forbade judges to rely on earlier case law. If judges had doubt, again, they would have to put questions to the legislator in the form of a special commission on statutes. Yet again, such a référé législatif was unsuccessful and was abandoned a couple decades later. French attempts to require judges to refer individual cases back to the legislator were equally unsuccessful. The Discours préliminaire of the French Code Civil of 1804, I think, does draw some very nice lessons from history and all the failed attempts to curtail the freedom of judges to interpret the law. Thank you. The drafters of the Code Civil, they recognized that even in a codified system, there must be case law. There must be jurisprudence, if only because judges cannot postpone a decision and because the legislator cannot foresee each and every civil matter that could arise, as also indicated by the speakers before me. So there will be gaps, there will be voids, and thus we need case law. So if we look back, there's always been case law. It is rational, and one could even say it's inevitable. The second strand of thought, through continental legal history, particularly at the beginning of the 19th century, is that judicial lawmaking and a mandatory rule on precedent are suspicious or even undemocratic. Montesquieu, for example, was of the view that the judge should be no more than la bouche de la loi, the mouth of the law, a very famous quote. And the rationale behind his views is twofold. First, Montesquieu and many other authors of the Revolution emphasized fundamental rights of citizens. These fundamental rights could only be constrained by law, and an overly extensive interpretation of laws by judges could pose a threat to the people's freedom or their property. And so this much reflects the thinking of Professor Wu before me. A second argument he raised is that the doctrine of the separation of powers implied that the people, and only the people, could make general rules. In his view, a system of binding precedent is in its core undemocratic. In France, I think it's important to understand, under the Ancien regime, the higher courts regularly rendered arrêts de règlement. These were general rules, often structured and numbered like statutes. And under the new regime, that practice was considered to be undesirable. Article 5 of the French Code Civil of 1804 thus clarified that judges are forbidden to decide cases submitted to them by way of general and regulatory provisions. This provision was implemented in large parts of Europe, yet again also in small parts of Lithuania, and still is enforced today in France and the Netherlands. Article 73 of the 1848 Statuto Albertino, which would later be the Italian constitution, clarified that the interpretation of laws in the form of obligatory upon all citizens belongs exclusively to the legislator. This constitutional rule does not prohibit judicial interpretation, nor does it bar judges from considering case law. It certainly does imply that there can be no mandatory or strict de jure rules on precedent. In the Netherlands, a 19th century scholar summarized a view that was, at the time, widely held, that legislation was the only true source of law. And as a result, a judge was formally not bound by case law, however unanimous and established it would be. No doubt, the selection of quotes that I have presented to you are very outspoken, and much has changed since. Yet, the fundamental constitutional perspectives have continued to shape the way we think about judicial lawmaking as well as precedent. I thank you for your attention.
Thank you very much.
You need to switch out. Okay, thank you. Dabar stoviu prieš dilemą, ar kalbėti apie tai, ką esu suplanavęs, ar reaguoti.
Well, I'm thinking about whether to talk about what I've already prepared or to react to what has been said. First of all, let me congratulate the Supreme Court of Lithuania, which has been successfully implementing its missions to ensure uniform interpretation and application of law in the courts of the Republic of Lithuania for more than 30 years. This is a very responsible mission, preventing chaos in our state and in Lithuania. This mission has been carried out through what is called precedent since the Constitutional Court's ruling of 28th of March to 2006. Today, there's not a single Supreme Court in Europe that does not rely on its previous case law. Courts do this for obvious reasons, both substantive legal reasons, such as ensuring equality before the law and the courts, which I remind you are general principles of EU law, and systemic reasons which facilitate the administration of justice, the reasoning of court decisions, and strengthen the legitimacy of the judicial system and public acceptance of its decisions. Of course, it is self-evident that the concept of precedents is far from universally applied across all legal systems. In the ruling of 20th of March, that ruling was widely discussed in Lithuania, but we could have seen that it was a major turn in the Lithuanian legal system. And it has to do not only with the use of term precedent, which can be interpreted broadly. and which can be understood broadly and without direct ties to the stare decisis doctrine. But from the clear statement that courts, when deciding cases of certain categories, are bound by their own precedents, decisions in analogous cases. The word bound is linguistically unambiguous and does not lend itself to interpretation suggesting that courts might sometimes not be bound even when they disagree with the earlier decision. Nevertheless, in reality, no radical shift occurred because in the Constitutional Court, as the Constitutional Court significantly softened its position in its ruling in 2007, and in that ruling the word bound remained only in the descriptive part. In the new ruling, much softer formulations are used, such as precedent is followed or precedent is taken into account. Since the Constitutional Courts provided rules for resolving precedent conflicts, such as considering whether the precedent reflects established judicial practice or is it an isolated case, the persuasiveness of the reasoners, it's clear that there was neither the intention nor the possibility of creating a true precedent-based legal system in Lithuania. Because in a pure precedent system, precedent conflicts should not arise in principle. If all courts follow earlier precedents, there's no room for such conflict. Thus, from the constitutional doctrine of precedent and its implementation by Lithuanian courts, we can see that no revolution has taken place, and I'm happy about it. However, a positive impact remains. And it is manifested by greater respect by courts for previous case law, increased attentiveness to ensure earlier jurisprudence is not overlooked, and transparent reasoning when prior judicial practice is changed. The Constitutional Court aims at stating in a transparent way the changes in its practice. And despite the Constitutional Court introducing terminology typical of common law systems, such as precedent, Lithuanian practice remains a country of the continental legal tradition, where courts use precedent de facto as a persuasive source of legal interpretation. And this introduction brings me to the real subject of my speech, the relevance of precedent in the case law of the Court of Justice of the European Union, and I'll try to go over it in a brief manner. It's no secret that the legal system of the European Union has developed to a large extent thanks to the decisions of the Court of Justice, which have given a breakthrough to the autonomy of this legal order, its sui generis status, its difference from classical international law. Today, it's common to speak in keywords such as the Kobler Doctrine, the Frankovich Doctrine, and every lawyer immediately recalls the corresponding rulings of the Court of Justice. Some researchers have calculated that, on average, the Court of Justice relies on 4 previous decisions in its rulings. However, my personal impression is that the number is higher. Nevertheless, the Court of Justice has never used the term precedent in its case law. However, any observer has no doubt that this court is faithful to its own case law. It's not easy to say whether this reliance on precedents is merely needed to ensure consistency in practice or a formal obligation to comply with what has previously been decided. In relation to national courts, preliminary rulings of the European Court of Justice have erga omnes effect and are binding on the courts of the member states. Such decisions are not limited to the facts and circumstances of the individual case,
horizontaliame santykyje Teisingumo teismo viduje.
However, within the European Court of Justice, it has never acknowledged that it's not bound by its previous practice. Advocate General Ms. Kokot stated in her opinion suggesting that the court's previous case law should be adjusted, stated the following, that the judgments of the Court of Justice are not binding precedents. While it is quite natural that the Court of Justice is not inclined to depart from its previous judgments, it has already had many opportunities in the past in a number of important cases to reconsider its previous practices. Yes, there have been such opportunities. However, throughout the court's life, there have been very few cases in which the court has openly adjusted its case law. Legal doctrine counts 4 such cases. I would add one more, bringing the total to 5. And one of the most recent examples is of the Court of Justice is the Banco de Santander case. In that case, the issue arose regarding the legal status of the Spanish Central Economic and Administrative Court and its ability to refer questions to the Court of Justice of preliminary ruling. In reality, the institution, this institution is related to the Ministry of Economy and Finance. And just to remind you, according to the consistent case law of the Court of Justice, when assessing whether an institution qualifies as a court of or tribunal within the meaning of Article 265 is
nepriklausomumo kriterijus atitiko. Ir jo pateikti prejudiciniai klausimai buvo pripažinti priimtinais. Praėjus 20 mečių.
After 20 years, the Court of Justice came back to this issue, and throughout these 20 years, the judicial independence doctrine has been evolving, and it is necessary to recall the case law from the Portuguese judges' cases. And for these reasons, the court said that its previous arguments had to be revised. Those considerations must be re-examined. In the legal jargon of the Court of Justice, this is a strong wording which implies a change in established case law. Undoubtedly, it's not as strong and aggressive as the one used by the U.S. Supreme Court in the famous 2022 case, Dobbs versus Jackson women's health case, as Professor Wu mentioned. The change in the case law of the Court of Justice is not based on an error in previous practice, but on the developments that took place over 20 years. And the Spanish Central Economic and Administrative Court no longer met those independence criteria. Very often the European Court of Justice is criticized because it deviates from its previous practices. However, it does not justify the reasons why it is done. Very often this court uses the distinguishing technique, identifying how several cases are different. The correlation of the Court of Justice to its previous practice can be understood by reading the statement by Advocate General, and the Advocate General's assistance to the Court of Justice in such cases ensures the transparency and comprehensibility of the case law. The Court of Justice of the European Union and its approach to the doctrine of precedent, namely its de jure non-recognition but de facto strong adherence to previous decisions, ensures that its case law is binding on national courts while also being continuously refined to closely follow developments in law and society. Thank you.
Dėkoju labai visiems pranešėjam ir dabar
Thank you to our speakers. And now I turn to the audience for questions. You can use the microphones available from the place you are sitting at. So now let's throw it open now for questions. Well, I believe there's some intimidation lingering in the room following some very impressive presentations. But yes, I see you have a question, please. Well, I don't want to take much of our time, but I would like to respond to Professor Mikelena's claim that the court is involved in building law. That's a fundamental statement which is grounded in the importance of courts in any legal system. The creative element in the case law of courts is beyond doubt. In any discourse, the courts respecting the division of powers have never denied that. And so we can speak about the retroactive aspect of invoking precedents. Lex retro non agit is certainly the principle that applies to law. And if we apply the lex principle, then this means that retro non agit principle can also be invoked. So is case law considered to be lex? Certainly different approaches can be invoked. But the European Court of Justice has always maintained that interpretation of law, the most creative one, goes beyond statutes, norms, customs, and is not involved in creative activities, which basically justifies its previous decisions, with the exception of a few cases related to some severe economic consequences when it limits its reasoning to a specific timing. In the case of Defren, it looks into the retroactive application of precedents, explaining that if a retroactive aspect is invoked, this means that every woman from the past will go to court to seek compensation for the losses incurred because of injustices in the past. So my question to you is whether or not you maintain that position, that courts are involved in building law. Because at a more conceptual level, I believe there should be a more nuanced approach taken. Well, I used the word illusion in my presentation too. And what is illusion? That's a defective understanding of reality. So my response to you would be, if the European Court of Justice have said that they only apply law and they're not engaged in building it, then I believe they are disillusioned. They live in the world of illusions. I could just only add by saying that Oliver Wendell Holmes, well, I've read a lot of his pieces of work. So he once said, I undoubtedly admit that judges are involved in building law, but they can only do that indirectly. What does it mean? Professor Remy mentioned Justinian and others. So we can treat this in terms of constant or perpetuate rivalry between parliaments and the judiciary. You have many examples when both clash. Let's take Israel as an example. When Benjamin Netanyahu wanted to conduct a reform and limit the powers of the Israeli Supreme Court, the Swiss parliament also had a reaction to the case on climate change by the European Court of Justice. The parliament said, no, we will not follow this ruling. Well, let's take the US again. Just take a look at the battle going on between President Trump and the courts there. How many executive orders of his have been suspended by courts? We'll see what's going to happen next. And let's take Lithuania's example and the case of accounting for parliamentary activities. And so the parliament is now trying to change the procedure to avoid the erroneous practices. Professor, I believe you wanted to react? I saw you making notes. Well, it's dangerous to give me the floor because I'll never stop. Well, I like that saying about living in an illusionary world. Well, I don't believe we can say that there's a half-pregnant person. That no such thing exists. So with all due respect to the saying that a precedent which is not binding, I believe that it's again something that is an illusion. We can call precedent soft law, but the fact that the word precedent was not part of our doctrine does not mean that they did not exist. There are many things that do not exist in the Constitution. The final draft of the Constitution was delivered in 3 days and nights, something that I continue to quote all the time. If we look at that text, we'll find so many gaps existing there, but this did not mean that there are some things that are not contained in the Constitution, even though they're not specifically written there. And let's admit that the courts are involved indeed in building law. And the Luxembourg court is not inclined to use the word precedent, yet it still does not mean that they do not rely on precedents, whether we deem them precedents or not. Let's take a look at the Strasbourg court. That one, quite on the contrary, is not intimidated to call its own previous rulings as precedents. The difference is quite obvious between the two. Strasbourg court is a kind of court where each judge has its own individual opinion, and the judges there can deliver their own separate opinions. Sometimes the rulings of the court may not be as convincing as expected, but they can always be a bolder opponent in delivering those rulings that will be willing to indicate certain gaps existing in the ruling of the court. In the meantime, in the Luxembourg court, a separate opinion by a judge cannot be delivered there. So this could be an explanation in response to your question. But as for the retroactive aspect of precedents, I have to say that I've received some criticism in this regard. Well, those who are involved in criminal law, you know that everyone who receives a life imprisonment are in the case Wilke. Soon, any person who is imprisoned according to the case is entitled to release before time. But very soon there was another case that trumped this rule. An interesting case in Hungary, however, there was a case where the case came right before the winter case in the Strasbourg court. No infringement was established. Hungary managed to improve its legal system by improving the situation of those imprisoned. But after delivering a ruling in the winter case, this case reached the court, and it only made sure that the court adopted a different decision. So all of that was related to the retroactive aspect of a precedent. In general, it was a very problematic situation because the Court of Strasbourg changed its practice, and somehow some of the decisions that were made in the past were deemed erroneous in the next cases. Well, you've mentioned the US, so I would now like to turn to Professor Wu. Speaking perhaps in abstract terms, the current political context in the US and certain tensions that exist there, would you see any potential threat for the stare decisis doctrine in the US, bearing in mind the existing context right now?
Okay. Well, that's a very difficult question. It is very interesting in the US right now. And there are many people who are questioning whether what's happened is going to be an attack on rule of law. And I think your question really is asking less whether the stare decisis system is going to be undermined, but more really the question of the power of the judiciary. And I think that the power of the judiciary still stands in the US. I could be wrong. The present administration is definitely pushing the concept of rule of law by issuing orders that either conflict with law or is beyond presidential authority through these executive orders. But these orders are all being challenged in the court system. And the court system is still operating under the stare decisis principle. And so what that would require really is for the court system to stand firm and to apply the law under the stare decisis system. So the stare decisis system, I don't think is going to change. The real question is whether the appointment of judges have changed such that judges will manipulate the stare decisis system to justify their interpretation to support even arguably illegal action. So just to get back to your question, I think stare decisis would stand, but stare decisis is always pretty malleable. Stare decisis required judges to explain their decisions. That will still stand. But with the political appointment of judges, you will have judges coming out with decisions to support arguably illegal decisions, but based on very good very elaborate explanations under stare decisis. So, my prediction, I think the system will still stand, stare decisis will still stand, but it is really getting a lot of knocks, a lot of hits in the meantime.
Thank you. Gal kažkas jau čia kažkas buvo?
Are there any questions in the audience? Yes, you can ask a question from your seat. You have microphones.
Gal ir kiti nesat pamatę.
Gal ir kiti nemato.
Maybe the others have failed to notice that you have microphones in your seat, in front of you. You can open a certain drawer. I would like to thank the presenters. It was a true food for thought, but as the president of the Supreme Court, I expect practical advice and recipes how to move forward. And from what I've heard, and maybe Professor Mikelenas has especially expressed it very clearly, the Supreme Court should move to formulating rules in its rulings, and we should start teaching our students that it's important to know how to write cassation appeals, and lawyers should know how to do that. I'm not sure if all speakers are of the same opinion that this is the right way to move forward. I understand it has been highlighted that it is important that our society, broad society, and our lower courts understand what is the essence of certain rulings, and clearly formulated rules would help with that. And it was the case in the Supreme Court. Maybe it depends on the on presidents of those courts, and certain presidents encouraged to formulate those rules very clearly. Professor Mikelenas said that he found more than 90 rulings, but they were all in civil cases. So my opinion is that we should formulate rules and admit that the rulings in different cases, in terms of civil and criminal cases, are different. I would like to ask everyone, would you agree that this would be the right direction for the Supreme Court of Lithuania? And do you have a good recipe how to do that, how to move forward? I would be very grateful if you shared your opinions. I have no doubts that certain thoughts are useful for other courts, for my colleagues from other courts, because the topic of ensuring uniform judicial practice has been very relevant this year and will continue to be very relevant.
I have a quick response to that, and I'm not in a position to recommend what the Lithuania Supreme Court should do or not do, but I do want to add and point out that in a system of precedent, and I'm talking about binding precedent, where the precedent has the authority of law. What it does require is not only better training of law students so that they can become judges, very well versed in writing opinions and outlining the rationale for the opinions, but the system might even have to change in a fundamental manner, which is to give lawyers more participation and authority. In the US system, I mean, to have a precedent system is a lot of work for judges, first of all. And to have lawyers to be able to find the cases and make the appropriate arguments really help judges a lot. So there's a practical reasoning for giving more authority to lawyers. But a more kind of systemic protection reasoning, you want to give more authority to lawyers to participate in finding the cases and arguing the cases, because it really is one way to check the judicial authority. We don't want judges to go out there and say, well, I like this one, and so I'll follow this one, or I'll like this one, and I'll follow this decision. If you have participation of parties to give more democratic authority to parties in cases, then I think you will have a system that is much more measured and much more susceptible to being a rule of law system.
I would like to comment too, a little differently from the American perspective, but taking up a little bit what I told you about legal services in Supreme Courts. I think there is a need to have a support if you really go for the formulation of sentences, legal sentences, maybe precedents, but you have to be aware about the abstractness of these sentences. So whom do you want to address? The citizen, jurists, lower courts, lawyers? This is a very important question to be decided. When you go for legal services, then within the court it might also be an issue to ask, are these services directly depending on the president? This was in Austria in the 19th century already an issue. Yeah? Is it a kind of internal control? And here I might add an anecdote I experienced when I was in Luxembourg at the Max Planck Institute. And we invited justices from the Strasbourg court to discuss a little bit Chatham House rules, how they establish binding case law. And they have a practice that the registry of the court, which has grown considerably over the last years, is strongly involved in the sense that they check the draft judgment and they tell the justices on Fridays whether there is a clear deviation from it or not. And if there is a deviation, they get a WhatsApp or an SMS. And they don't like it at all, because this means additional workload over the weekend. Yeah? I do not tell you that I find this a bad solution. So there is a need to have some review whether there is a consistency, because this is really a basic task of a Supreme Court. But then one really has a little bit to think about the way how this consistency is finally established. A different way is certainly, but you know it much better, Mr. Noldus, than I do, the Advocate General. They can criticize a little bit the line of case law. They can make a proposal to go in a different direction. The court might take it up, not take it up. This is a little bit the success rate of an Advocate General. But this is also an objective way of looking at case law, at practice, which helps a lot. So I think it needs an organizational way of making it. And the last remark, I should tell you that in the Evidence Bureau, so in the legal services of the Austrian Supreme Court, there are students of Vienna University dealing with the legal sentences. So they learn it very early, and we had recently a debate in the faculty whether we should go for these services because they are costly. And the answer of the majority was quite clear. We have a genuine interest in sending our students to the Supreme Court to do that task.
Yes, getting to the question of the President. I think one of the challenges for a European lawyer or judge these days is information overflow. The US Supreme Court renders a reasonable amount of judgments, right? That's doable. On one topic, there may be 3 decisions, whereas we learned from Professor Hess that it's 50 in the list in Austria. And it gets worse if you take into account that there are sometimes constitutional courts. There's a European Court of Human Rights. We've just heard there's a Court of Justice. So there's not one court that is, important and one should consider. There's a bunch of them. Then take into look international tribunals, perhaps, and whatever else there may be. It is becoming a bit of a challenge. I think some courts have good ideas, like the Court of Human Rights, so that make it easy for the user to distinguish a relevant case from an irrelevant one, right? And that's quite clear. You can find it on the site. And Grand Chamber, for example, is always important. And if it's just a small bench and there's no further notes and it isn't referred to, it's less important. Some systems, like the Dutch, have similar rules, but they're more implicit. They're not really written down. But if there's a bench of 3, then it's less important than if it's a bench of 5. And I think each legal system has this, and I think this is becoming inevitable. In a system with information overflow, justice should be concerned with, trying to help people to distinguish, particularly like in France and Italy, where you've got hundreds or even thousands of cases rendered by high courts, some system of distinguishing between the ones that are relevant from a legal perspective and those that are not. Yeah. Thank you.
Galiu trumpai, jeigu prašo praktinių patarimų, gerbiamo teismo pirmininkė.
If you're asking for practical advice, it's a massive task, and we should cooperate with universities, and universities should also revise their programs. I don't know about the universities in other places, but some universities have a module on how to find law. Another practical matter, Valentinas talked about 96 rulings on the same issue. So we should not rely on keywords, but introduce the criteria of a rule. Then maybe we would not end up with 96 rulings. We had a certain criteria and we had certain keywords. So we need to work with criteria, otherwise we have a jambalaya. I can only add that the rulings of the Supreme Court and its quality, the writing technique has improved since 2001. The progress has been made, but it's not all. Of course, you cannot formulate the rule of interpretation and application of law in every single case. Even though there's a selection system, but you receive certain appeals that are more difficult. We can't expect that every ruling of the Supreme Court would have that rule. Looking into the future, I'm a pessimist, because our education system is ruined. Universities accept very weak students. More and more students cannot write their own thesis. So who's going to work in those courts in the future? The knowledge of mathematics of our students are the words in the European Union. And if one is a bad mathematician, he cannot be a good lawyer.
Labai trumpai, tai be abejo, aiški teisė ir aiški teismų.
Clear case law is a value. The more clear arguments are provided by the Supreme Court, the better it is for the society.
Numato, kad nutartyje turi būti teisės aiškinimo taisyklė, bet ne teisėkūros taisyklė, nes žodžiai čia taip pat irgi turi prasmę, bet be abejo viskas, kaip profesorius Mikelėnas.
And as Professor Mikelėnas said, everything is working within the system.
Vienas iš kasacijos pagrindų yra nukrypimas nuo kasacinio teismo praktikos. Praktika aiški, bet žemesnės instancijos teismas.
And sometimes the practice is very clear, but lower courts deviate from those practices.
Kurs kažkokią teisės aiškinimo taisyklę.
Ačiū.
Professor Nekrošius, I would like to join the discussion. I'll be very brief. Deviating from judicial practice can also be a rule. When the Supreme Court explains in one state that certain evidence cannot be heard in one court, it can be a deviation.
Dėl tos taisyklės, man atrodo, kad ten dabar išbrauktas tas reikalavimas iš CPK yra. 7 ar 8, neišbrauktas. Tai pirmininkė, tai ką jūs klausite? Ar įstatymo laikytis? Ne, tai aš tai nesiūlau. Jokių būdų, aš buvau.
Well, I did not suggest removing that rule. I was the one who, together with Professor who was in charge of writing it. Well, you were asked how to implement that rule. Well, you have to look at the cassation cases. I believe we have a lot of case law on the maintenance of children, that we're so much, in fact, that we are forced to repeat ourselves too much. The Supreme Court, as it rules itself, is a court of cassation. Everyone is aware as to what cassation means. And if it's so, then we should be involved in cassation, per se. Once we do that, we'll have enough rules to abide by. Perhaps we should include in our case law the rule that if we deviate from some kind of previous law, then we should not be involved in writing new ones. But whenever we're not delivering new rules, we should make sure that we have less rulings where new rules are formulated. If we take 20 cases, let's say, of the Supreme Court, we'll find in 1 or 2 cases a rule delivered there, because that's a tendency, whereas in the remainder of the 18 cases, you will not find a new rule developed, because you will be ruling on the payback of a loan, where the decision is quite clear in such case. And I would just like to wish the Supreme Court to make sure that it becomes a court with full competence of cassation, because it has been in place for so many years now.
We are finishing now, finalizing. Or you want to say something? No. Just to leave.
Yes, thank you very
much. Thank you.
Could I just say one thing too? So maybe I'm not understanding the Lithuania's.
Please turn on the microphone.
I did.
Yeah.
Okay.
We can hear you.
Just to follow up on the last comment, maybe I don't understand the Lithuanian Supreme Court system. At least in the United States, when you have cases go up to the Supreme Court, it has to go through a petition, a writ certiorari. So almost every case that goes up to the Supreme Court is it's really challenging a particular rule. It's not just a review of a decision. And so one way of establishing a precedent system may be to have that kind of a criteria before you have the Supreme Court issue and hear cases. That it really is focusing on a new legal doctrine or application of a legal doctrine.
We have criteria defined in the law, what kind of issues the Supreme Court decides. So basically the comments and the critique was towards the implementation of these criteria, not that. So basically, you did understand correctly how the Supreme Court works in Lithuania. Gerai, tai liko 1 minutė ir nebent kas nors.
Well then, 1 minute remains, and unless somebody wants to make an extremely positive comment with regards to the Supreme Court of Lithuania, let me then announce the end of this part of the conference and invite you all for lunch. And let's come back in an hour for the continuation.
Welcome back. I hope that you all had some time for rest and you had some food for thought. And I hope that our interpreters also had time for rest. Therefore, I would like to welcome you to part 2 of the conference titled Preliminary Rulings in the Supreme Court, Comparative Aspects and Future Perspectives. And without much ado, I would like to give the floor to our keynote speaker, professor from the Leiden University, Professor Dr. Bart Kranz. And here's one of the main reasons why we're here today and why we included preliminary rulings into our conference. In 2023 in Madrid, I heard the presentation by Professor on this topic, and I was really interested in this method. And after the conference, I went to the president of the court and asked her whether she knew about preliminary rulings. The president was aware of that topic, but in this context, certain internal and external discussion started, which actually resulted in the topic of part 2 of our conference. So, Professor, the floor is yours.
dear esteemed hosts, dear colleagues, dear friends, as we all know, during a conference day like this, there's always one moment that is by far the hardest moment, directly after lunch. So, in other words, if you survive the next 15 minutes, you'll make drinks afterwards as well. What will we talk about today? Well, the first hour of my presentation, I would like to sketch a bit the outlines of the idea. In the second hour, I will go into the practice, and in the third hour, just before the sun comes up tomorrow morning, I will try to speak about the evaluation of the Act. No, do not worry. I am very well aware that I am the last hurdle between you and the next coffee break, so I'll keep track of time. Don't worry about that, and I mean that. The Dutch preliminary ruling procedure, questions from lower courts to the Supreme Court. Why talking about a Dutch national instrument? Why a Dutch national instrument? We are at a wonderful organized conference in Vilnius. A Dutch national instrument. We are not a very tiny country, okay, overcrowded, but not very tiny. We're not as large as Germany or Spain, but why a Dutch instrument? We are celebrating historical events in Lithuania. Congratulations with 30 years of the Supreme Court. Why here? Well, first of all, today I'm not on a sales market. I'm not to pitch the Dutch topic. But let me try to tell you the experience with it in the Netherlands and how we experience the Act. It may be interesting to see why it was introduced and what our first ideas are and how it turns out. So that may fit wonderful to the very well organized, the wonderful theme of this very well organized conference, ensuring uniform legal practice. So although just the Netherlands, it may fit after all. Let's see. An overview. What is it about? And I will try to sketch you the rationale. Why did we introduce it? And are we happy with the system? It's a relatively new instrument in Dutch law, relatively new, introduced in 2012. And I know a few other countries, legal countries, that have a more or less comparable mechanism. For example, Italy has introduced in rather recent years a more or less comparable mechanism. And I just heard over coffee that Finland very recently introduced an act like that as well. But it does not seem to be very common. Germany does not have such an act, at least not for general cases. And I've been reading your Lithuanian Code of Civil Procedure with great interest, at least the version I could find on the World Wide Web, at least in English, because my Lithuanian is far from perfect. So I tried, and what I could find from that English version, it does not yet exist here. Belgium does not have it, and just to mention one other country, Japan, they do not have it yet. So it does seem to be a relatively new instrument. In July 2012, so just about 13 years ago, in the Netherlands, the Act on Preliminary Ruling Procedure came into force. And based on this act, lower courts can ask questions directly to the Supreme Court without handing over the case. The case stays at the lower court level, but the lower court asks a question to the Supreme Court. It has nothing to do, it is not the same as the question, the preliminary ruling procedure to Luxembourg. We do not take the train or the plane to Luxembourg. We stay in the national system. A route to Luxembourg is possible, but this is a pure national mechanism. So lower courts can ask questions to the Dutch Supreme Court. They can only ask questions on a matter of law, not on the application, only a matter of law. I will come back on that. So district courts and courts of appeal, we have as usual a three-tier system. District courts and courts of appeal can ask questions to the Dutch Supreme Court. Only matters of law, and that matter of law must be relevant for other cases. Not just other cases, many other cases, numerous other cases. If it may be relevant for numerous other cases, then the question may be taken into answer. So it is not a regular system of proceedings in cassation. It's not the regular route of cases going up to the Supreme Court. The case stays at the level. And this act came into force in 2012. Are we happy with it? Well, that will be my last slide, but let me give you a spoiler alert. Are we happy with it? The answer is in 3 letters. Yes. Yes. There is even room for improvement. And why are we happy with it? And how can I prove that we're happy with it? It's not proof in procedural way, but let me show you some reasons why we at least have presumption that we're happy with it. Let me go into the act and mention some examples why we have it and why it's considered, at least in the Netherlands, more or less a success. Why was it introduced? As I said, in 2012. The idea for this act dates from 2008. There was a report made up by a commission, and the name of the report, Versterking Cassatierechtspraak in English, Report on the Strengthening of Cassation in Justice. It was written by some prestigious members of the Dutch Supreme Court and some high-ranking civil servants from the Ministry of Justice. And that report concerned the position and the role of the Dutch Supreme Court. And as far as the role of the Dutch Supreme Court was concerned, several problems were identified. Supreme Court hears many cases, many cases, a bit less in lower years, but they hear many cases. Nevertheless, at the same time, it was established that although they hear many cases, not all the important legal issues come up to the Supreme Court. There are many practical reasons why important legal issues do not reach the Supreme Court. Consumers perhaps don't want to continue proceeding, don't want to take it up to the Court of Appeal or to the Supreme Court. Or, let's say, the repeat players, the big boys and girls, don't want to take it up because they prefer settlement. For many reasons, it can be there that important legal questions do not reach the Supreme Court. So, does it mean that the Supreme Court, being busy, only handles with minor cases? That's not entirely true, but there is we identified some imbalance. Many legal issues not reaching up, and still a lot of work to do. Not good for legal unity, and not good for the development of the law. And after all, monitoring legal unity and the development of the law are far from unimportant tasks. No, to put it more clearly, are important tasks for the Supreme Court, I guess, in almost all countries. Therefore, the Commission in 2008, they proposed a mechanism like this. Let's pave the road to ask questions to the Dutch Supreme Court. Why? What are the pros, possible pros? And this option, of course, has pros and cons. What are possible pros? Well, according to parliamentary doctrines, because there was a parliamentary debate on the Act, what were the possible pros? First of all, we can get rapid clarity on important answers. The possibility of obtaining rapid clarity in highest instance on important questions of law. It may save time. It may save time and provide rapid clarity on issues we would not have reached the Supreme Court anyway. Is it only applicable in mass cases? No. We started with mass cases, it was the idea, but in the end we started the debate with mass cases, but when the Act was enforced, it's not only applicable in mass cases. And the advantage of rapid clarity is very clear. But it will not only provide rapid clarity, so we expect it, but it may also prevent individual claims. It may also prevent many individual claims. Because if cases stay at the level of the district court of a court of appeal, we have many district courts in the Netherlands. Well, perhaps I'm telling you a secret, but also in the Netherlands, judges, they're just like humans. They don't all agree. So the district court in Amsterdam and the district court in Rotterdam, they will not by definition give the same ruling. The outcomes may be contradicting. In Amsterdam, Rotterdam, Groningen or Maastricht, the decisions may be varying. They may be even contradicting. If this mechanism works, so anticipated, you may prevent many contradicting outcomes. And so perhaps we thought and we hoped it may prevent contradicting outcomes on first instance. So if this works, it promotes legal unity and provides rapid clarity. And it also provides, that's what we hoped, a more optimal performance of the law-making tasks of the civil chamber. That's some gravitas in those words, with the law-making task of the civil chamber. But it seems to work. It seems to work. And the cases where we needed the answer were cases where the social need for response was quite clear. So, main pros which we thought there would be when we are thinking about, will this act be enforced, yes or no? As always, not just pros, but also some cons. What also some cons? Okay, if we introduce this mechanism and we give district courts of appeal the option to ask questions, that takes time. The question must be asked. The question must be formulated. Perhaps they want to consult parties on whether or not to ask the question. And perhaps the district courts, is this the real question? Do we need to reformulate the question? How many questions? And if we ask the question, it goes up to the Supreme Court. Well, the Supreme Court, they're not just, no, they're, what do we do and how many times is it? So it causes delays for the proceedings in first instance or the courts of appeal. So delay and perhaps complication. There's a possible downside, but not just. That's the possible downside. The other possible downside is, judge in a district court. This is an important question. It's also a rather difficult question. I do like answering questions, but I prefer not to answer difficult questions. Can I shift this workload to the Supreme Court? That may prevent, that they later tell me that I was wrong. I prefer asking the question. So, is there a risk of shifting workload to the Supreme Court? Question mark, question mark. So, these downsides were mentioned before we introduced the Act. Now it is there. The question is there, and let's turn to the Act itself. How does it work? First of all, when? What are the conditions for referring? When can a district court or a court of appeal refer to the Supreme Court? First of all, according to Article 392 of the Dutch Code of Civil Procedure, there are several requirements. I only mention the important ones. I will skip the details. It must concern a question of law. Only a question of law, not the application in this case, but only the rule of law on this type of cases. What is the rule of law? The answer to the question must be relevant for the district court or court of appeal to decide on this case. So only a matter of law, relevant for this case, and the third one, it must be relevant for a multitude of other cases. A multitude of other cases. It must have direct relevance for a large number of claims based on the same or similar facts or arising from similar or connected causes. That's an important precondition. So, to put it in short, two main requirements. A matter of law and relevant for a multitude of other cases based on the same facts or similar causes. And a multitude or numerous other cases, that's an important one. And that criterion is addressed by the district courts. Now, 12, 13 years later, we can identify that that question is answered by the district court itself. The Supreme Court is, well, I cannot say relaxed in this matter. The Supreme Court is talking about relaxed in the Supreme Court way. That's not appropriate. We cannot say they consider it chill. No, that's not appropriate. But they take it in rather easily. It's left up to the district courts or courts of appeal whether they consider it is already being addressed in numerous other cases. But the criterion is often supplemented by, let's say, the social context in which the question arises. What is the social context? And what are the financial interests of the party? And the relevance for other parties, such as an advisory practice for the Dutch Commission on dispute rent committees. And the Supreme Court seems rather flexible in this matter. They have, as far as I've seen, very seldom or perhaps never refused the question on this matter. It's not allowed to say, it perhaps may be relevant for some cases in the future. The option that there will be other cases, that's not enough. That's not enough. That's a threshold we cannot go below. But once you pass the threshold and you can identify and you have serious presumption that it's relevant for other cases, then the door will be open. Well, once we start the preliminary procedure, what happens? The district court or the court of appeal can ask questions. They can ask questions because the parties request for it. It can be claimant, it can be defendant, it can be a joint request. We formulate a question and we send it to The Hague. But the court can also ask a question ex officio, so without one of the parties asking the question. They can even ask the question if the party said, that is not necessary, we don't want you to do that, maybe even, well, it may stay these proceedings. It may complicate the proceeding, but if the court says, it's my decision, they can do so. If the district court or the Court of Appeal decides to ask a question, proceedings before the district court are suspended on the spot. So they are suspended. Case is taken up to The Hague, at least only these questions to the Supreme Court in The Hague, and those proceedings are suspended until the decision from the Supreme Court is received. Until the decision of the Supreme Court is received. It's only applicable in cases where a multitude of other numerous cases are pending or perhaps may be pending. So it's very likely that if the district court in, let's say, Amsterdam asks a question, a similar case may already be pending in Rotterdam or another district court. So these other cases may be suspended as well. As one Amsterdam asked a question, the Rotterdam case may be suspended as well. So they may suspend it as well. The question arrives at the Supreme Court and they decide on what we call in the Netherlands the red light or green light decision. It has nothing to do with a red pill or a blue pill, that's something else. No, red light or green light decision. Do we open the door, yes or no? So they will have to decide on, will we answer the question yes or no? And it's generally concerned among Dutch scholars as the red light or green light decision. And what do they take into account? In deciding is it whether red light or green light, is it a question of law? Is it relevant for a multitude of other cases? Or, for example, is the question already answered? Is it perhaps like an acte éclairé or an acte clair? Is it already answered? Could they known it? Those are questions to take into account whether to put a light on red or green. If one of those examples occurs, it's the end of the line, that's where the train stops and it will be red light. Another question, another reason to turn the light on red, maybe they say, okay, but it's not important enough. It is important, but not important enough. What about practice so far? Which button did they push so far? It turns out that only in a very, very limited number of cases, the Supreme Court has turned the light on red. In the vast majority of cases, not all of them, but almost all of them, they said, you're welcome, bring it on. We'll answer it. I guess only so far, in 3 or 4 times, perhaps 5 now, they've said, no, this is not, we don't take it in, but the vast majority, they took in the question. So it seems to be a threshold which they take seriously, but the threshold seems to be rather low in practice. It's not a threshold you cannot pass. What do they do after green light? If the question passes this threshold and the Supreme Court picks it up, what's the follow procedure? How do we go on? Well, the question is asked not by the parties, but by the court. The court asked the question. Nevertheless, the litigating parties are entitled to submit their views to the Supreme Court. So the litigating parties can submit their views to the Supreme Court. In fact, the Supreme Court can even give third persons the option to bring forward their views. They are not only entitled to, in fact, they do. How do they do so? In a very practical way. Once the question reaches the Supreme Court, the question is published on the website of the Supreme Court. There's a special section on the website of the Supreme Court. I will not try now not to make any practical, technical difficulties now, but there's a special section on the website of the Dutch Supreme Court, prejudiciële vragen, preliminary question, where you can find this question came in and this is the status of the question. So everybody can see that this question is pending. So it's simply there. Everybody can read, not only the litigating parties, but also third person. And they deliberately put it on their website because they want everybody to have the opportunity to bring forward their views. Why? Because it may be relevant for other cases as well. In fact, the Dutch Supreme Court can even decide they want to reach out to certain third persons or organizations. Do you want to bring forward your views? Association of insurance companies, Association of Consumer Association, Association of Medical Doctors, which type of association use, Association of Judicial Officers, what kind, they can do that. But so far, if I'm correctly, they very seldom done. I know one case where an Attorney General asked for information. I think it was Attorney General Hartlief who asked information on the type of information you have to bring forward in a medical liability case. He asked information on the Association of Consumer Association, the Association of Medical Insurance Lawyers, the Association of Insurance Companies, but it was the only one. In the vast majority, it's not specifically asked, but everybody can bring forward their views if they want to do so. And usually, if they do so, it are well, let's say my words, umbrella association, consumers association, bank associations, insurance companies, etc. There's one requirement for bringing forward your views to the Supreme Court. It must be done by a lawyer, and by a lawyer who is entitled to proceed before the Supreme Court. So not just any lawyer, but let's say, to simplify, a Supreme Court lawyer. So you must formulate your question by a Supreme Court lawyer, which, well, usually they don't work for free, usually. So that costs money. Once that's done, once that door has been opened and perhaps views have been forward, it's up to the Supreme Court. And the Supreme Court can reformulate the question, just as Strasbourg can do, just as Strasbourg can be done. The Hague can also reformulate the question. Well, how long does it take? What about the duration of these proceedings? These proceedings are given some precedence by the Dutch Supreme Court. They rank it a bit higher as a way of speed. I will spare you the details, but in the first 5 or 6 years, it took them about, well, roughly saying 6 or 7 months to give an answer. And that is faster than the regular proceedings. It's a bit complicated because if you want to know exactly how much time it takes, you have to know at what time does the district court does the district court start thinking about asking a question, and start thinking about the question and deliberate with party about the question. But it depends a bit. It's a bit hard to say. It depends on how you calculate the numbers. But it was about 220 days, and now in a publication with my colleague Kastermans and our PhD student Marije Ploem, we found out that now it's a bit more, about 420 days, but it depends on where you start counting. Nowadays, to summarize it, it's more or less the same as a regular cassation proceeding. Perhaps sometimes a bit faster, sometimes a bit slower. After the answer of the Supreme Court, what's happened? Once the Supreme Court has answered the decision, what happens? The decision goes back to the lower court, and the lower court will resume handling the case, bearing in mind the answer of the Supreme Court. So the lower court continues handling the case, because the Supreme Court has only decided on the matter of law, not on the application of it, because that's up to the district court. So they did not give an answer for this specific case. They do not rule, does the litigant win, does the claimant win, or the defendant win. They only said, this is the matter of law, this is the answer. It's up to the district court to decide who can claim the victory and who cannot. So in theory, this means that once the district court has given its decision, well, it's just the decision of a district court. You can take it up in appeal, and the case can be dealt with in appeal again. And once the Court of Appeal has decided on it, well, they can take it up to the Supreme Court. So the case can reach the Supreme Court. Again. Again? Again? Yes or no? Again? Yes, it was the same matter of law, but not on the application. So yes, again, but then they have to decide, was it applied in a correct way? But they are bound by their own previous ruling on the matter of law. So it can reach the Supreme Court for the second time. They have to take into account what they ruled earlier on the rule of law, and now they have to decide, if it reaches there, was this rule of law applied in the correct way? And there's one other route, which is not on the slide, but the Supreme Court can also decide, this is difficult. We need our colleagues in Strasbourg to answer the question. And perhaps, and to be even complicated, perhaps a district court can turn himself directly to Strasbourg. But that was a complication we anticipated, but so far that was, well, fear for cold water, which is unjustified. It has never happened so far. So the collision with the Strasbourg route has not happened so far. Well, theory. Give me some examples and numbers. Okay, here they are. Some numbers. What numbers can we give you? The Act came into force in 2012. In June 2021, the Supreme Court received question number 100. Question number 100. So, 100 questions in almost 9 years. Is that a lot? Is it not a lot? Depends on other numbers. Well, to summarize, it is much more than we expected when the Act was introduced. Much more. Just to give you an idea, the Dutch Supreme Court ruled in more or less around 300, between 355 cases, 350 cases per year, now a bit less, so 100 per year. It is much more. 100 preliminary decisions in 9 years, it's a lot for a new instrument. In fact, when question number 100 reached the Supreme Court, the Supreme Court sent out a message on which was called in that days Twitter. So they X'd on it and they said, we have received question number 100. I think without an emoticon, but question number 100. So, and even send out a message, there's question number 100. A milestone, the Supreme Court called it. If we take a look at those first 100 cases, what can we see? 68 questions were asked by district courts and 32 questions by courts of appeal. And which district courts? You might expect Amsterdam, Rotterdam, that's only half the truth. The main district courts asking the questions are Amsterdam and The Hague. So the district court in Amsterdam and The Hague. And up to today, because this was after 2021, up to today, in 140 cases, questions are asked. So in recent years, to give you an idea, more or less between 12 and 14 cases, questions per year. And the Supreme Court usually deals with 200, 250 cases per year. So between 10 and 15 cases per year now reached the Supreme Court in this preliminary ruling procedure. Are these questions only asked in regular proceedings, or can they also be asked in summary proceedings? That was a bit debatable. There's no legal obstacle for asking questions like that in summary proceedings. It is possible. And it does happen. It turns out that all the 140 cases so far, in 12 cases, questions were asked in summary proceedings. And that may sound strange, because the goal of a summary proceeding is the need for speed, the need for a clear answer. We must know it now. And still, we want to stay those proceedings, we want to suspend them, because we need the answer of the Supreme Court. In fact, in some of these summary proceedings, the court said to the proceeding parties, we want to ask questions to the Supreme Court. We ask you not to do it because we need the speed. And still, the district court, deciding in summary proceedings, asked the question to the Supreme Court. Those are exceptions, but it has happened so far. So that's the case. It does happen. What are the questions so far? It turns out, if we look at those 140 cases, it turns out what are the questions concern? They concern mainly the areas you can see on these bullet points: the insolvency law, procedure law, family law, law of damages, and far from surprising, consumer law. Let me just mention, these are the areas which the questions are most of. Just to give you an example, some, well, to put it in Hollywood terms, high-profile cases. What were the cases about? High profile is a bit exaggerated, but let's see what were they about. First one, I will not mention all of them, don't worry. The telecom case. If a consumer enters an agreement with a service provider about service contract for your mobile phone, what contract do you enter? Do you just pay for the services of the telecom provider? Or do you also pay for the mobile phone if the mobile phone is included? Free mobile phones! The fairy tale of the free mobile phones. So it's a matter of substantive law, but it may be relevant for the rules on consumer credit. Do you only pay for the service provider? So you're able to call and to send your WhatsApp messages to home and colleagues, or do you also pay for the machine? So it was called a fairy tale of the free mobile phones. That was a question asked to the Supreme Court. The other one, damage to house number 3, damage to houses. In the northern part of the Netherlands, several houses, many houses, hundreds of houses, perhaps thousands of houses, were seriously damaged as a result of gas drilling. As a result of gas drilling by oil companies. How to assess the damages? I'll spare you the details, but how to assess the damages? At what time do you have to assess the damages for establishing the damages for these houses? An important decision for thousands and thousands of inhabitants of that area of the Netherlands. A question put to the Supreme Court. Or Airbnb, same one. Or not the last one, but almost the last one. The rental reduction during the pandemic. During the pandemic, are small companies, are they entitled to a rental reduction? They could almost not have their regular turnover or the regular profit, but the rent stayed at the same level. So that may cause serious problems. Are they entitled to rental reduction? Question reaches the Supreme Court, and the Supreme Court says, yes, rental reduction. And just a relatively recent one. If we buy something online, and the ordering button, if you click now, you order it. Is that ordering button, does that make sufficiently clear that you enter an agreement? According to European law, it must be clear for a consumer that you enter an agreement. It was not quite clear in the Dutch law. And the Supreme Court ruled, just this ordering button, it's not clear enough. And I will spare you the details, but it's really clear that this decision on the ordering button, it's not clear enough under Dutch law. That's very practical relevant. That has direct implications for the practice of the online ordering button, the bestelknop in Dutch, the ordering button. So, just some high-profile cases. In all of these cases, the Dutch Supreme Court gave an answer. So, once this, I'll wrap up. Once question number 100 was received in 2022, more or less, the Dutch Supreme Court organized a conference. And the man who was presiding that conference in the room, the Vice President of the Dutch Supreme Court, Martijn Polak, was presiding that conference, and the Dutch Supreme Court set out a survey among district courts and courts of appeal. Among district courts and courts of appeal, you ask questions, please give us your ideas on this mechanism. Are you happy with it or not? Are you happy with it or not? And the general idea was the district courts and courts of appeal said, yes, we were happy. We can work with it. There's room for improvement, but that was in general the idea. So the judges who asked the questions more or less said, yes, we're happy. Does it have negative aspects? Of course. Some Dutch lawyers say, the Supreme Court, they like it perhaps a bit too much. Perhaps they consider it, to exaggerate, as their pet child. That's not entirely true, but that is one of the aspects. And okay, perhaps they could be a little bit stricter on red light, green light. And perhaps the cost of a mandatory cassation lawyer. That's something we have to think about. So those are the aspects mentioned so far. Some final remarks. Don't worry, and I'll keep my word. How can I more or less prove or give you the idea that we're happy with it? This new toy was developed for civil cases. The toy store gave us only this option for civil cases. But then our esteemed colleagues from tax law noticed our numbers and said, oh, they from civil law have a new toy and it works, they're happy with it. Can we buy it as well? It's also introduced in tax cases a couple of years later. And then our friends in criminal law noticed the system. It works in civil law, it works in tax law, can we please have it as well? So it's expanding in the Netherlands, and now it's even argued that it should be opened for administrative cases. And that's even a step further, because the highest court in the Netherlands on administrative case is not the Dutch Supreme Court. It's another court, so that's another step away, but as a way of illustrating that we consider it, in large lines, a success. Is it perfect? No. Is there room for improvement? Absolutely. Is there room what is one of the ideas, room for improvement? I will only mention it, because esteemed Dutch colleague Martijn Polak will deal with it more. How to deal with third parties or third persons and bring forward their views. That's one of the options where there's room for improvement. Are we happy with the fact so far? Am I happy with your attention so far? Very, very much. Thank you for that.
Thank you very much, Professor. I have no doubt that your presentation is first very excellent, and second, that definitely will serve as an excellent basis for our upcoming discussion. But as of now, I need to declare a short coffee break for around 15 minutes. So let's be back at 3:05. Skelbiu trumpą kavos pertrauką ir sugrįžtame po 15 minučių, tai yra 5 minutės.
An announcement of the coffee break to be back.
Gerai, tai sveiki dar kartelį, pradedame.
Good afternoon. Let's begin the discussion of part 2 of the conference. And as for introductory remarks, during the first part, we spoke about the ruling of the Constitutional Court, about how we apply its ruling. In the second part of our conference, we're going to focus on the future. We're going to take a specific procedural instrument which is not present in Lithuania, and we'll see if it can be applied in our case law. And this panel consists of professors, law professionals, and they will help us with from several perspectives. We're going to listen to how this instrument is implemented in other jurisdictions, the Netherlands, Poland, and Finland. We'll also hear a skeptical take on this tool, about the shortcomings of this tool. And as for the participants, you are in a very unique position because you have the opportunity to form your own opinion on this tool and to think about whether it can be applied in the Republic of Lithuania. And please, if you can come up with questions for our speakers. Without further ado, I would like to give the floor to the first speaker. And this is Vice President and Chairman of the Civil Law Chamber of the Hoge der Nederlanden, Judge Mr. Martin Pollack, who's going to talk about, whose presentation is titled "The Netherlands, May We Have Your Votes, Please?"
Thank you, Mr. Chairman, and also a warm word of gratitude to the organizers of this conference, a truly European conference of lawyers, and that's why I chose this title, because it reminded me of a European song contest where we vote for each other and hope at the end of the day that our country will win. Now, I'm not going to try to gain votes for the Netherlands. I'd rather have your votes on what you think of our present situation, and Professor Bart Krans has already given you a splendid overview. So let me just highlight a few issues, concerns, and an inside perspective on the present preliminary reference mechanism in the Netherlands. Briefly on the genesis of the present preliminary reference mechanism, as already mentioned by Professor Krans, there were, I think, two concerns that we tried to address. One is that there are legal questions that never reach the Hoge Raad, the Supreme Court, because of the limited financial impact of certain types of cases. That is especially true for instance, consumer cases, the rent of houses, and sometimes also procedural questions in cases with a limited financial amount. And there was also the concern that there are questions that do reach the Supreme Court at a certain point in time, but that it is after lengthy litigation in first and second instance. The example mentioned there was a lot of litigation in the Netherlands about financial products, where the financial impact was big, but the litigation was taking years and years, and once the cases reached the Supreme Court, it was already 5 or 6 years after the first cases came up. So the search was for a new instrument, and that was eventually the preliminary reference mechanism. And maybe it's also important to stress, and that is my second bullet point, that this new instrument is an addition to what was already in place. If you want to understand our system, you have to keep in mind that we have, in fact, 3 channels by which cases may reach the Hoge Raad, the Supreme Court. There is, of course, the regular appeal in cassation, which is lodged by the litigating parties or by one of the litigating parties. That takes up about 95% of our caseload. Then we have, already for decades, a special procedure that is an appeal to the Hoge Raad, which is lodged by an Advocate General on the interest of law. That is the situation whereby a case is brought to the Supreme Court also on a point of law, and where the decision by the Supreme Court does not affect the outcome of the case for the parties. So it does not prejudice the parties' rights that were settled by the lower court. Those were 2 channels already in place, and the preliminary reference procedure was added to it, with the result that nowadays there are, in fact, 3 players that may reach the Supreme Court: the litigating parties, the Advocate General, and the lower court. So we are accessible from three sides, you might say. The only thing that we cannot do, and I'm grateful for this, that we cannot ex officio give decisions. Somebody must ask our involvement, of course, in a case. The parties, Advocate General, or a lower court. Turning then to what is perhaps an interesting point of insight, the criteria for admissibility. Professor Krantz has already explained that there is a statutory requirement saying you can only raise a preliminary question in a mass claim or in a multitude of similar cases. That's a statutory requirement, and the Supreme Court is supposed to review the admissibility at the beginning. Do we accept a case or not? And indeed, as he has said, the practice shows that the Supreme Court has a very loose, a non-strict review of the admissibility. Explanation, I think, is threefold. First of all, since it was a new instrument, we as the Supreme Court thought we should gather support for it, rather than be strict and tell the lower courts, oh, your question is out of order, or it's not completely satisfactory. We thought we should be welcoming questions, gathering support for this new instrument. And we also had to experiment, of course, with those admissibility requirements. Second explanation is that so far we have always, as the Supreme Court, substantiated a refusal. If we do not admit a question, the statute says we can limit our reasoning to a sort of mantra, a sort of formula by which we say, this case is not welcome, stop, next case. But so far we have always taken the trouble of substantiating our reasons for non-admissibility. And of course that takes more or less the same time as admitting the case and hearing it and deciding it. So there's no time saving by throwing out the case in advance at the beginning. And the third reason is that the statute also gives us the opportunity, once we have admitted the case, to reformulate it or to abstain from answering it after we have heard the parties. If we think the case is too complicated or is not fit, after careful investigation, we may still abstain from answering it. And indeed, we have done so in several cases. If time allows, I can give you the examples. That is about the admissibility criteria, where there is indeed a very loose review. And most cases, the 142 cases, I indeed believe that we have merely rejected about 10 cases in total for various reasons. Most often, we have refused to hear cases whereby the issue at stake was already in debate in Parliament. There was legislation underway. Lower courts wanted us to take a stand, and we said, well, we better wait for Parliament to do its job, and if it doesn't, then perhaps you'll come back. So, for instance, the latest case, which Professor Krantz could not include in his summary, which is the 142nd decision, was about registration of non-binary persons in the civil registry. We refused to answer that question about 3 years ago on the ground that Parliament was debating it, but the bill has been withdrawn from Parliament, and now lower courts come back and say, well, now the way is free for the Supreme Court to give us its wisdom on this issue. We'll see, we'll see. That's the newest case. Peculiar procedural aspects. I wanted to mention just two things. Has it already happened that in a preliminary reference proceeding, we, in our turn, had to address ourselves to the court in Luxembourg? Yes, that has been done on several occasions. A lower court in the Netherlands raised the question with us, realizing, of course, that it involved European law, European consumer law, for instance, and we felt obliged to submit the case to Luxembourg because it was a case where there was not an acte claire or an acte éclairé. You may wonder, why did the lower courts not directly approach the court in Luxembourg, because they have that opportunity. My impression is, if I'm not mistaken, that lower courts in the Netherlands think that the Supreme Court is better in formulating the right question. And as we all know, formulating the right question is rather important to get the right answer. Sometimes we do not raise any question because we will not like the answer anyway, but I haven't said this. But formulating the right question is quite important for getting the right answer. And indeed, there has been a case in the Netherlands whereby a lower court asked a question, we got the wrong answer. So after a few years as the Supreme Court, we reformulated the question and still got the wrong answer. But at least it was more well-reasoned decision. So in most cases, the lower courts address us and we then sort of put the ball into the Luxembourg soccer field. Is there a role for the Hoge Raad after the Court of Justice has answered? Yes, in several occasions there were still issues to be solved. So normally, whenever Luxembourg has given an answer to us, we reopen the case, we give an answer, and then the case is sent back to the lower courts. But that is a rather complicated sort of pyramid of proceedings, one after the other. Then the question that Professor Krantz already addressed, is there the possibility for a regular appeal to the Hoge Raad after a preliminary question? Yes, there's no legal impediment. It could happen that after we have answered a preliminary reference question that the district court or the Court of Appeal decides the case and that parties lodge a regular appeal. But so far that has not happened. So we're 13 years on the way, nearly 150 cases, but we have not yet had the experience with that. So are we bound by our earlier decision? You would say yes, but the limits of that are still to be clarified. That's something for the future. Brings me to evaluation. After 13 years, indeed we don't have to sell this product to anyone, but we can say that it was positively welcomed by most players in the field. Courts of first and second instance said yes. What is positive is the speed, especially in the beginning when we were able to answer within 6 months. Unfortunately, that is no longer possible. The answers themselves were considered to be useful. They added something to the status of the law. What was left is the question, can the questioning court itself play a role in the procedure? Many courts would like to give their views as well, not just raise the question, but also say, well, if you ask us, we would like to receive that answer. Our reply is, well, you can put that in your question, of course, and say, well, this is the problem, and we see 3 solutions, and please take number 1. There's nothing against it, but courts would like to have a further step and also sort of participate in debate. That is something for the future, whether or not that is a good idea. Supreme Court barristers, Hoge Raad barristers, they were a little bit less enthusiastic because they felt that the focus on this new procedure took away attention from the regular proceedings, and they're right. This is indeed our most cherished sort of work, and in very many regular cases we limit ourselves to very briefly motivated or non-even motivated decisions. So indeed their concern is well in point. Academic world regularly says yes. The new procedure contributes to legal uniformity and to legal development. We ourselves believe that this new instrument is an addition to the existing instruments, the regular appeal and the appeal lodged by the Advocate General. But we see a few challenges for the future that still need to be answered. On my last slide, there is always the question of what is the impact of this procedure on the total case law. It takes a lot of time. These are not the easiest questions. They are the most complicated ones that are put to us. Otherwise, the district courts or the courts of appeal would solve the issue themselves. So they face us with very difficult questions that take a lot of time. We promised to the lower courts that we would give these questions a sort of fast track, but we do not manage any longer. Parties' involvement takes time. We have to study things, so there is no longer the possibility to give these questions priority and time. So the question is, should we be stricter? Some people have advocated that we should be stricter, and we think ourselves that perhaps time has come before we are the victim of our own success. Maybe we should be stricter on the admissibility and say, well, it's an interesting question, but it doesn't play very often, so we better not take it into consideration. We are also dealing with the question, when, at what stage shall we be strict? We could refuse cases or some questions at the stage of admissibility, or we could say, well, let's hear parties, let's have everybody's input, and then decide not to address certain questions or rephrase questions. It's perhaps a bit of a waste of time and energy if you do it at that late stage, but on the other hand, you can say, well, at the beginning, it's very difficult to distinguish between useful and non-useful cases. So what's the ideal moment in time to be strict? That's something which we're not sure on. So far, we have mostly, in most cases, answered all the questions, all the details. And the last point, that is the most difficult one and also the interesting one. The preliminary questions usually deal with problems where a lot of parties in the Netherlands, non-governmental organizations, interest groups would like to be involved. And how do we organize the involvement of third parties, the amicus curiae position? The statute allows us to give parties and third parties a role. They may submit their opinions. But how do we organize it? Should we, as Supreme Court, invite parties, third parties, or is that in violation of our objective non-steering role? If we would say, well, we would like to have the opinion of this or that party, would that already affect our position? So far, we have not taken the initiative ourselves. We have waited for parties to sort of knock on the door, and then we said, you're welcome. We have not refused anybody so far. We also have a little bit to fear, what are we organizing? How can we organize it? Should we organize some sort of sitting like this for 3 days where everybody can come along and submit their views on an issue? Our practice is much more the old-fashioned way in which we do everything on paper. We don't have hearings so much, so we should reorganize ourselves if we were to organize these sort of, what you would call the United States Supreme Court hearings, 3 days hearings in court. Maybe that's the future, but so far it's not our practice. Those are the things that I would like to add to what Professor Krantz has already explained to you. And of course, if there are questions, I would be happy to address them afterwards. Thank you.
So thank you very much. So maybe not 12, but 10 points goes to the Netherlands. So. Thank you very much. Ačiū labai. Teisėjau ir nieko nelaukdamas pristatau antrąjį.
I would like to introduce the next participant of our discussion, and this is Professor Habilitated Dr. Vytautas Nekrošius. He's going to talk about the court's right to ask and the Constitution. Thank you. I'll try to speak slowly so the interpreters can keep up with me. I can't make any promises on that. Professor Krantz has been very convincing in telling how wonderful an instrument it is. So I give 12 points out of 12 to the Netherlands, but not to Lithuania. Why is that so? There are two reasons for that. First of all, in the Netherlands, they have never had any dictators. They've always had democracy for the past 300, 400 years. They have been developing. They didn't have any idiotic dictators. Everything was in order. And this act has entered into force in 12 years ago, and this is the main difference between our countries. We are also a very old democracy. Our democracy is 35 years old. Before that, we've never had a democracy. I'm not even talking about the Soviet times, but even the history of the Grand Duchy of Lithuania, unlike the Polish ones, we had different dukes. And our current democracy is rather fragile and rather weak, and people here probably remember recent times when one president was very happy that people are afraid to go to her office. So this is our starting positions. For this reason, the Netherlands receive 12 points and Lithuania receives 0. And I will try to make a case against this tool. In 2006, the Constitutional Court stated that consultations are against Constitution. But it's not just a text, there's a situation behind a certain text, and not the factual situation, but the general situation in Lithuania. And in 2006, we could not say yet that politicians and policy do not influence justice. So this instrument was one of the opportunities to influence justice. And politicians could interfere with the process of justice. Then later I can tell about how it could have been done, but I suppose most of us understand. Today it's 2025, and the question is very simple. Has our situation changed? Yes, situation has significantly improved since 2006. But I dare to say that essentially the situation has not changed. And you'll say that this is just my fantasy. Then I will give you a few cases without any comments in which politics had its influence. And I think it's rather obvious. Let's start with Serbs. There was a case of Petroševićus. I will not talk about it anymore. Those who know, they know. There was a weak man who was selling weapons to everyone. Another case was related to Inga Renau, on which even the Court of Human Rights spoke. There was the case of Garlava. We fought for the girl. Then we have the case of Eidukas in the Supreme Court. We have many, many cases. In some cases, the court did what it had to do, but that's not the point. The point is our attitude and our culture. And today in Lithuania, we don't have it. And if any politician in the Netherlands came up with an idea to directly or indirectly to ask the president of the Supreme Court to decide a case in one way or another, it would become known to everybody, and that politician would have to resign. And in our country, heads of the state can do that. So unfortunately, our situation is vastly different. So why am I against these preliminary rulings? Because we can say that in 2006, there was the Constitutional Court ruling, and consultation is not the same as preliminary rulings, but the essence is very similar. We need to have a broader view on the situation. Furthermore, what are the potential dangers? I say certain issues related to independence, because today the culture in Lithuania allows people to call judges and ask about things in certain cases. Maybe I am mistaken, and there might be such temptations and dangers for some people to do that, especially when it comes to the civil proceedings. I'm not a massive conservative, but if we cannot change, we must not change. And if we cannot regulate, we must not regulate. And have we got any alternatives? I think yes, we do have alternatives. Yes, we know that there are preliminary rulings in the Court of Justice. Yes. And talking about the Lithuanian law, we have judges who are very versed in Lithuanian law. They know about it very well. The European law is a different story. When 10 years ago, the late Marcel Storme was asked what is needed for the effective civil proceedings, his answer was that we need wise judges, not laws, not other things, but wise judges. And wise judge needs to have two features, the knowledge of law, first of all, and another part is wisdom, which does not have to do with law, which has to do with life, with its ability, with his or her ability to see the broader situation, to interpret the law, to apply it to a certain situation. So my opinion is that all institutions need to add to the development of those wise judges. Whether the preliminary rulings would add to this goal, will it make our judges wise? And there are judges who refuse to the order of court for some strange reasons. They refuse to do that. But those preliminary rulings will add more workload to the Supreme Court, and those questions sometimes the way for other courts to avoid working, and because they might not want to deal with some sensitive cases, with some difficult cases, they will want to ask the Supreme Court for its opinion. And this practice with these consultations was that the Supreme Court would receive questions regarding on whether the people should stand up at the beginning of a court hearing. I don't know whether this question is very meaningful. So my view is that in Lithuania we have a lot of problems related to this tool. I will never be in favor for this tool. Are there any other ways? Yes, we might introduce something when we have nothing else to do, but we have cassation. We have summaries, and courts can take them into account. We have training. Yes, in the Supreme Court, you know what the problems are, so you can organize certain relevant training, and that's it. It will be very helpful. And finally, my last point. I don't like certain trends that I see. I don't like when our politicians, in terms of education, start talking about the fact that children should feel good at school all the time, and only then they can engage in studies. Well, my opinion is that the main task of children is to study. They have to respect their parents and they have to study. And in our country, these values are being reversed. So this tool adds to this process. And when the Supreme Court answers to the judge of a district court, whose decision is going to be that? Is it going to be the decision of the judge of the district judge or the Supreme Court? So what I wanted to say is that we have to make every effort into bringing about wise judges in the Lithuanian courts. If we have wise judges, we won't need any preliminary rulings. Thank you.
Thank you very much, Professor. And our next speaker will speak on preliminary questions in the Supreme Court, a new method in Finland. And this will be presented by Dr. Tatu Lepanen, President of the Supreme Court of Finland.
To everybody, dear colleagues, it's really a privilege and a pleasure to be able to speak here to you all, and congratulations to the court for the anniversary. After the presentation of Professor Nekrosius, I have to admit that I and my dear colleague, President Eka, we are from the Nordic countries, and we have very well-functioning societies, high trust in public institutions, and I would also say that our legal culture is very practical, down to earth, everyday life. As our colleague from the Danish Supreme Court said that in our courts things seem to just flow easily without real efforts from us presidents. But from that background, I'm not trying to pitch or sell anything here. We have different histories and legal cultures and so on, and similarities and dissimilarities. I will only tell you about the situation in Finland. So I was asked to speak about our brand new domestic preliminary reference system, but as background, just a few words of our role in general in normal appellate procedures. So we have jurisdiction in civil and criminal cases. We have three-layer court system: district courts, appellate courts, and the Supreme Court. And our main task is to guide case law clearly by establishing judicial precedents. So we are not afraid to say we are a court of precedent, clearly. And how do we do that? We have a compact court, 18 justices and one president. We have a strong filtering system. So admissibility of a case requires granting of a leave to appeal to the Supreme Court. And the far most important ground to have a leave is that the case has presidential value in other cases. So we get roughly 2,000 cases per year. We give leave in around 120 cases, so 6 to 7% of the cases. And of the leaves, 80% are granted on the presidential value of the case. One difference is also that, similarly like in other Nordic countries, after we have granted the leave, we work as an appellate court. So we are not a court of cassation. We rule on the merits of the case. We give a new judgment. We normally don't send the case back to the lower court. Normally we grant the leave in questions of law, but we can grant the leave also on questions of fact. And we can take the evidence again and work as an appellate court. So a bit different role for us. And on precedents, we don't have, they are not formally binding. We don't have stare decisis system, but they are respected, and I would say they are highly respected and followed in practice by the lower courts and other legal professionals. There's one exception. We ourselves are formally bound by our own precedents. If we want to give a new precedent, make another opinion, we must have a larger panel or a full panel. So a panel can't change a precedent without a stronger panel or full panel. So that's about the background of our role in normal appeal cases. So our new system, our preliminary reference system, I have to say we don't have as high numbers as our Dutch friends have. So as I said, this is brand new. In Finland, the highest courts have, according to the constitution, a possibility to give a formal legislative proposal. We did it in 23. We looked at the Dutch example and Swedish example and so on, and found this a useful new tool. We made a proposal. It was accepted by the government, which gave a bill to the parliament, and it was accepted in the parliament, mainly in the content that we proposed. There are now new provisions in the Code of Judicial Procedure, which came into force in April this year. So little over 4 months experience of this new system. And the reasons for your system in the Netherlands seems very familiar to us. The first aim was to further enhance the possibilities of the Supreme Court to give guidance, especially in civil law, especially in cases with minor economical value, which don't normally come at all to the Supreme Court, because civil litigation is extremely expensive, at least in Finland, so they normally stop already in the district court, especially in consumer cases. And the other aim were these process economical benefits in those proceedings where this new tool will be used, such that you get the answer from the Supreme Court in the beginning of the proceedings, so the litigation can continue from this basis, and not to have judgment and appeal and judgment, and only after that to the Supreme Court. And especially in these cases where, for example, after new legislation or new developments, in many pending litigations, it will be very useful to get an answer from the Supreme Court in the beginning. For example, 2 years ago, we had many drug offense cases in different district courts, which were based on the evidence gathered by FBI in the United States. So in every case, there was the same question: is this evidence admissible in the Finnish criminal proceedings? So it was litigated in many cases, many district courts. They gave different answers, and the same was in the appellate court procedure. When the first procedure came to the Supreme Court, we gave the answer, it was admissible, and then the situation was clear. If this could have been done in the beginning, in the first case, so that would have helped the proceedings a lot. That could be one example. In the Parliament, especially, the delay factor was discussed. How long does it delay that the case goes in between to the Supreme Court? And we kind of promised that we will try to give the answer in 6 months. So we will try to keep our promise to the legislature. We give these questions fast track and answer them as soon as possible. So as I mentioned, it's brand new. We have very limited experience. Only one question has so far been referred. We have accepted it to be answered, but we have not yet answered it. So this is the first case. It concerns the real estate law in Åland Island. So it's a very peculiar case. So we are hoping to get more general questions in the near future. It would be interesting to hear how have you reached these high numbers, maybe in the discussion period. So also according to our sections, a district court, a court of appeal, but also a market court, which is a special court in IPR and commercial cases, may refer a question to the Supreme Court. It must be a question concerning the application of the law that arises in a pending case under consideration. So I see a difference, not perhaps so qualitative, but to some extent difference in our system than in the Dutch system, because we see that it must be a question in concreto. We are not deciding the case, but the district court says the facts in this question are this. How do you interpret the law in light of these facts? And then we answer about the interpretation, and the court continues. So in that sense, we have seen it must be questioning concreto. If it would be questioning abstracto, we saw that it would go too far to the legislators' field. And then you have these questions, should third parties be involved? If you have very abstract questions, abstract answers, they affect a lot of different parties. So what is a three-party presentation? So we try to concentrate on the facts. Then I think we don't need this third-party intervention. In Finland, already from the beginning, it can be either in civil or criminal cases. We have seen that the need is bigger in civil cases. And of course, in criminal cases, there are restrictions. There are at many times urgent cases which can't wait the 6 months, which we are hoping to achieve. They can concern the procedural law, the example of admissibility of evidence, for example, or material law. There are practical limitations. For example, if the relevant facts are in dispute, we can't answer that. We can't rule on evidentiary questions in that sense. The proposal to refer may come from the referring court or the parties, but normally the question cannot be referred against the parties' opinion. And this is cooperation between the referring court and the Supreme Court. It's dialogue. On contrary to the Luxembourg preliminary reference system, the district court never is obliged to ask. There is no obligation to ask. It may ask in this case. And we, under these conditions, may answer. So it's a cooperation. When acting this legislation, it was thoroughly scrutinized from the point of view of our constitution. We saw no constitutional obstacles. It enhances the legal protection and the rights of the individuals, and the independence of the courts is respected. Thus, in this, the law court considers if it asks, and we consider if we answer, so we are both independent. The Supreme Court may decide to consider the question if it is important with regard to the application of the law in other similar cases, or because of the need to ensure uniformity of judicial practice. And the same as in the Netherlands, after our part, the referring court will resume its consideration of the case. And in this system, our ruling, our answer is binding for the lower court in the proceedings in that case. It's like a middle decision or something like that in that case. But otherwise, it has the same precedential value as other precedents. So in other cases, it's not stare decisis, like no precedent from ours. So it's binding in that case. Other cases, it has the same precedential value. I can also mention we have special provision that each party is responsible for bearing its own legal costs in this special proceedings. Well, that was my presentation. Thank you.
Thank you. It was very interesting to hear the Finnish experience, and last but not least, maybe the best participant of discussion is Dr. Alexandra Klik from Faculty of Law and Administration from University of Szczecin, and she's going to talk about preliminary questions as an instrument of judicial supervision by the Supreme Court of the Polish legal system.
on behalf of Professor Flaga Gieruszyńska and me for inviting us for this conference. As you can see, the presentation was prepared by Professor Kinga Flaga Gieruszyńska and me, but unfortunately, Professor needed to stay in Szczecin because of her duty as a Vice Rector. This is an honor for me to present and to share our thoughts with such an enormous experts and esteemed group of experts. But as Professor Kranzas was very enthusiastic to preliminary questions, and Professor Nekrosius was a little bit or more skeptic, I should be in the middle. If I do, I don't know. I should also say thank you for attention because my time is over, but I will try to do my best for keep at least time limitation. As you can see, in Poland, the preliminary questions are regulated both in civil and criminal procedures. As Professor said about new toy, our toy is quite ancient. It's not new, because preliminary questions were regulated for years in Polish legal system, not only in civil and criminal, also in administrative procedure. What should I mention about this? This institution is known, I think, approx 100 years in Poland, and still it's active. And the legal system, since long the time, these preliminary questions are existing. Is it good? As an attorney at law, I would say it depends if this solution is good or not, because this is, of course, national mechanism, as in Dutch law system. But what can we provide from this solution? That main aim is to harmonize judgments by Supreme Court, which is addressed to district and appeal courts. This is the main role. As you can see, parties are not allowed to ask the preliminary question to the Supreme Court, because this is dedicated to courts of appeals, courts of second instance in civil proceedings, and court of appeals in criminal proceedings. When we were trying to find some positive ways and positive thoughts of these preliminary questions, both with Professor, we maybe not created, but we highlighted some functions of the role of these preliminary questions in Polish legal system. First of all, supervisory. This is, from the one hand, this is quite important. From the other, it's a little bit risky for independence if we are thinking about the role of judgments. So this supervisory function is connected with that the Supreme Court exercises judicial supervision over common courts and preliminary rulings, alongside cassation and abstract resolutions. So they are one of the main tools of this supervision. Secondly, interpretative function. So the Supreme Court removes, or try to remove, serious legal doubts while the appeal proceedings are still ongoing. So providing courts with some kind of guidance on how to interpret the law. Thirdly, guarantee. Supporters of this idea of preliminary questions would say that questions compensate for the limited availability of cassation and protect the rights of the parties, ensuring greater legal certainty and predictability of decisions. But do we have quasi-lawmaking? This is something that I'm asking, and I'm wondering if we say it depends or not. But fourthly, this function means that the Supreme Court consolidates the legal system by filling gaps and clarifying provisions. Is this the role of Supreme Court? I think that we can divide our answers to yes and no, but I'm not so sure if the answer will be so clear. So the line between interpretation and creation of law, so using and creating the law, is very thin in this point of view, this quasi-law lawmaking. Systemic function, these preliminary rulings, they should, and of course they can, stabilize the legal system and reduce discrepancies in case law. And finally, educational function, which is dedicated, or resolution serve as a point of reference for other courts, but also for attorneys, for parties and legal doctrine, improving the quality of law enforcement in practice. I talked about the way of asking these questions, that courts are only allowed to ask preliminary questions. So they are not, parties are not allowed to ask directly Supreme Court. But what they are doing, basically their attorneys, they are trying to show to the Court of Appeal that asking the preliminary question is so needed to this case because the problem is so deep and not easy to resolve it. So they are in practice. I'm attorney at law, so I can share with this. I'm not doing this, but I'm sharing with some experience that they're suggesting, dear district court or dear appeal court, please check, please formulate this preliminary question, because I'm sure that this is so deep problem that you won't be able to answer in the judgment. The form of answering to the preliminary questions is resolution. So this is something what is, this is the form. In exceptional cases, the resolution can be addressed to individual case and to in general. In exceptional situation, in exceptional cases, resolution may have the role of force of the law, the rule of the law. These resolutions are held by 7 Supreme Court judges, mixed chamber or whole chamber. And what is quite important in Poland, that if they are treated like rule of law, it means that they are not only dedicated to individual case, but all other courts should follow this resolution. We had such situation with a very hot topic last day, so Swiss franc loans, that our Supreme Court gave resolution, created resolution which was completely basic for attorneys, for parties, for judges. I will try to mention about this a little bit later. What about these questions? The structure of legal question, of preliminary question, should include these elements that you can see on the slides. But formally, it binds only the case in which it was asked. But in practice, lower courts are also in practice. They are trying to follow these resolutions, and they rarely depart from it, which ensures consistency of judgment, because this is the main aim for regulating and for using these preliminary questions. Examples. 3 main fields that we wanted to share with you, fields where there are lots of preliminary questions, labor law, consumer cases, and the star of the superstar last days, especially in Poland, so Swiss franc loans. With these cases, this practical significance and examples are really important, as you can see, from the social perspective. And there are the resolutions are regulating lot of, maybe not things, but a lot of rules that are in this hole of not understanding properly the rules, or where we have some gaps in the rules. The result is that the resolutions have social and economic impact, hundreds, thousands of cases throughout Poland. And this is something that we need to focus on and to think about current challenges. Because first challenge and first risk is overburdening of the Supreme Court, overloaded of the Supreme Court. I checked very quickly during Professor's presentation how many cases we had in civil chamber, how many questions we had in civil chamber from 2020. For last 5 years, it was more than 500 preliminary questions, only in civil chamber. We have there now 31 judges. In total, we can have 36 judges in civil chamber. But these are not only judges who are judging this creating resolutions, because they are normally judging in other cases. So this shows that the court is overloaded. Second thing, limited power of resolutions, and they are only binding in a given case. So when, of course, these preliminary questions are connected with the case. I forgot to mention about that the question has to be connected only with legal issues, not fact, not finding facts, not evidences. So if there is a preliminary question which is created for specific case, it means that the resolution will be addressed to this type of case. Of course, they can be very similar, like for consumer cases or Swiss loan, franc Swiss loans, that we can use it in the future, but not always they will fit for 100% or for 99% to the other case. But in practice, they are judges, lower courts, also attorneys, and also legal doctrine. We are trying to compare these resolutions also to, or address it also to other cases. And especially in mass cases, this is something which is visible, especially with consumer law. We saw a few years ago that the resolutions which were addressed to the abusive clause while creating contracts did a great or not job for the parties while checking the abusive clauses, if they are abusive or not. And this was the field, except of labor law, it was the field that was the most popular with preliminary questions. And in conclusions, so these preliminary rulings, does it mean that Supreme Court is oversight mechanism? I'm a little bit afraid that when we are talking about preliminary questions, that especially when Supreme Court is also cassation court, that this court will change to court of law, so-called court of law, and that we will have this situation that basically in practice we have it a little bit, we are living in a little bit illusion that we are not having precedents. But I think that somehow we have it, especially when we are trying to follow the judgment statements and when we have such resolutions which are treated as rule of law. And I will leave you with the question, should the power of Supreme Court resolution and the role of preliminary rulings, not only in Poland, but I think in other countries which have this institution, which are thinking about this, or which are against this institution, if they should be strengthened or not. So if we have a court who is using the law, who is following the law, or if we have court which is creating the law with such resolutions. Thank you so much for your attention.
Thank you very much for sharing the experience of Poland. And now we have some time for discussions and for the questions answers. And before moving to our audience, I would like to ask whether our speakers would like to react or to respond to the presentations of their colleagues or to add to what they have already said. Please, the floor is yours.
Renew my question. So, how did the system got into the air? How was it well taken by the practitioners?
In the Netherlands, you mean?
In the Netherlands, because we have only one question so far.
Yes, I think that from the beginning there was enthusiasm all over, both by practitioners and by lower courts. So there was no need to actually promote the instrument. The only thing that, as a Supreme Court, we did was to, as I said, is to welcome all cases that were submitted to us, not to make the threshold too high. That was the only thing that we had to contribute to the, and of course do our best in addressing the questions in time and give a substantive answer. But it was not a difficult issue to. Everybody was convinced in the Netherlands that this was a useful new instrument. Yes, yes. But I must admit, of course, that as you said for Finland and for Sweden, that the Netherlands also is, as you call it, a high trust society in which it is easy, and maybe very different from the situation you describe. It's easy for us to say that that the independence of courts vis-à-vis each other, higher courts, lower courts, that is, in my view, not an issue in the Netherlands. Lower courts are brave enough to tell us as Supreme Court that we are wrong if they really think so, and they're welcome to do so. So I think that we are in the luxury position in the Netherlands that we have, at least in the legal system, an open society. I'm not talking about the politics these days, that's a different story. That's more for the drinks afterwards, where I will tell you what I think. But for the legal world in the Netherlands, we are in a high trust, respectful situation whereby criticism and cooperation is our key words. So, and that is, of course, a very important background to all of this. That I agree with you that that is indispensable. Yeah.
Well, actually, I agreed to what has been said. Well, I've heard an argument in favor of this mechanism that it is time-saving. This is absolutely irrelevant for Lithuania because we are the first in Europe according to the short duration of considering cases. We could slow down a bit. We take a year, for example, to take the case through all three instances of court, so we don't need this saving of time. But in essence, the measure is positive with all the advantages it entails. But I always compare advantages and disadvantages and threats and pros, and I see many more threats in case of Lithuania as to this tool. I have one question to the Dutch side. As far as I understand, the court of the first instance in the Netherlands keeps a certain discretion not to abide by the response of the Supreme Court. Or are there any situations when the decision of the Supreme Court is binding? What is the discretion of the court of the first instance? Is it the case that the courts of the first instance take the decision of the Supreme Court and apply it directly and take the according decision?
Well, formally, the Dutch district courts are entitled to do whatever they want. But in practice, they follow the decision of the Supreme Court. Because directly after, when they well, more or less disobey, they will be quashed in appeal at the Supreme Court. So there's no formal ruling of President Work, but in practice they do. What they do is once the answer from the Supreme Court is given, they apply this rule to the facts of this case, because it's not completely an abstract rule, but apply it to this case, and that means that one of the parties will win. They have, so far as I know, in the cases so far as I've seen, they have not one case where they say, Supreme Court is wrong. And in other cases where they disagree with the Supreme Court, as colleague Polak said, they will tell so. And they will also say, if there's a regular case and we disagree with the view of the Supreme Court, they will do so, and sometimes they deliberately do so. But in these cases, I haven't seen it formally no binding fact, but in practice, yes, it is.
There is an interesting example that was a preliminary question to us is the relationship between somebody who's working for a platform like Deliveroo or Uber. Is he having an employment contract, or is that a sui generis contract where you don't have the protection of social security and labor law, etc.? And a very difficult question, which is also on the agenda in the European Union to harmonize rules in that respect, but so far it's up to national law. And we studied the whole material and we came up with a sort of test. This is the criterion. And in fact, we developed a 9-step test. At least it included 9 issues that you could consider or that you should consider before you could say yes or no, this is an employment contract. And we sent back the answer that we, after long cooking, made up. And the lower court said, oh, very interesting, but are you serious? So they raised another question and said, about issue number 9, shouldn't that be a little bit different? And we thought, my God, after so many months of thinking, are you seriously thinking that we would reconsider our decision within a year? So we said, well, yes, this was a serious message. Good luck with it, but it's 9 issues, and go ahead. So that demonstrates my point that courts in the Netherlands are independent enough to say, well, it's wisdom from the Supreme Court, but we don't take it. Yeah.
Tai ačiū labai. Tai kreipiuosi į auditoriją, ar auditorija turės klausimų, tai taip.
So my question goes to the audience. Do we have any questions?
And since I'm a president of the Supreme Court, I want to react to the words of Vytautas Nekrošius. According to the data of European Union, 62% and 62% of companies leaders in Lithuania and 56% of general public trust Lithuanian courts. And as we were celebrating the 30th anniversary of the cassation competence, we have been talking about that the rulings of courts are less commented on publicly, and I have never received any call from politicians asking to influence the decisions of the Supreme Court. And if we are scared of political influence, then we need to hear all cases in that way. And all the cases that you have mentioned, they are in the past, and certain cases, for example, the Garliava case, it demonstrates how the whole society heard a case, and there are certain similar cases in Sweden, Finland, the Netherlands, and there are cases and they cannot be avoided, and the whole of society gets involved, and it's not good necessarily for the outcome, and it's very difficult for judges. And talking about wise judges, well, it would seem that judges in the Netherlands and Finland are not wise, so they need preliminary rulings, but we're not talking about wisdom. I'm raising this question because today, as the president of the Supreme Council, I can't solve issues of ensuring uniform practice in certain cases. For example, cases on consumer credits, and we have 5 district laws with 5 district courts with different practices, and how can we solve that? And what are our solutions when we talk about quicker decisions, and there are certain cases which take a long time, but certain cases don't reach the Supreme Court of Lithuania. So how can we ensure uniform practice? So for this reason, I think this tool could be useful, and I believe that the judges are wise and they want to hear cases and they don't want to refer them to the judges of the Supreme Court. And still, I have certain questions that would bring some positivity, and as Professor Kranz said, and now let's go back to the numbers. And we are interested in the experience of the Netherlands and Poland. I remember what has been said by the Vice President of the Supreme Court said that no cases were returned. Question to the Polish colleague: do you have any numbers, statistics, when the case was heard according to the preliminary ruling? Did that case came back based on the cassation procedure? After certain cases were heard based on preliminary rulings, were peace agreements concluded after that? We talked about the ruling of the Constitutional Court in Lithuania, and it was against the consultations, and we are of the opinion that those consultations are not available. And can the Institute of Preliminary Rulings be introduced in Lithuania, and can it be compared to that consultations? Will they have the same effect? I understand that advice was slightly different. However, our colleagues from Finland said that preliminary rulings are related to specific cases and factual circumstances. And maybe for this reasons, there is a necessity to refer to the Court of Justice, because lower courts rarely go to the Court of Justice. How many of those factual circumstances are included in formulating preliminary rulings? Questions. And how many of those cases go to the Court of Justice?
Thank you. I think that, first of all, when we speak about the arguments, we should not consider whether I was called or not called or contacted by somebody. But we are analyzing the general situation on Garliava case. Why this became the social or the public case? Because politicians were involved in that. Well, speaking on trust, there are 3 types of lie, and the third one is statistics. And I use artificial intelligence and Luke Wilmore's survey, which shows 56% of public trust in public institutions. And another thing is when you speak about non-interference of politicians into the work of the judiciary. Quite recently, the Constitutional Court adopted a judgment on the partnership law. And look at what how politicians reacted to that. Now the question on the factual circumstances and presentation of factual circumstances when formulating preliminary question to the Supreme Court was asked to Poland. Well, question number 2 was asked to the Polish presenter on the number of circumstances presented.
Supreme Court is publishing statistics about the cases which are about cassations that they are coming, but when the preliminary question is addressed to the Supreme Court, it's registered on a different signature. So it's created like in a general form. So it's of course connected with the case, but it's formulated like a general question, and it's, I guess, I'm not sure for 100% now, but I guess that it's quite hard to check if this concrete preliminary question is connected to the concrete case, which will be like a cassation case to the court. So I'm not sure. I need to check this. I'm not sure if this is possible to connect these 2 separate, basically, things, and also this connection with case about registering. They have completely different signature. The main case and the case which is connected to preliminary questions. If I may, I would just add that in this ideal world that we have, that we would like to have, with the preliminary questions, I completely agree that the role of Supreme Court is to harmonize judgments, because when I see 2 paths of completely different way of understanding and interpreting the law, I am a little bit furious, because when I have one case in Szczecin and in Warsaw, and there are completely different paths, sometimes I'm writing one point of view, and for example, to the courts in Warsaw, I'm writing the things that my opponent was writing. So this is something what is quite hard task, but the biggest problem for me is when Supreme Court is changing their path, because such situation we had, especially with these preliminary questions, after the preliminary questions, it was good when Supreme Court noticed that previously we thought like this and this, but now we are changing this. But in ideal world, maybe it would be good to include this regulations, these resolutions created by Supreme Court, by legislator to resolve those problems. Of course, we can say in that case that then the Supreme Court will create the law, but I'm not so sure if we can say like this. Thank you, and sorry for adding this additional thing.
Professor Skransas norėjo pasisakyti.
Yes, may I?
Professor Hans.
over the years, Martijn, which, among others, by you as president of this court. The first point on wise judges. I think nobody is against wise judges. Who would be? But I'm not sure whether that's the problem here, because one of the issues is the cases do not reach the judges, so they don't get the chance to prove they're wise. That's where it all started. There are societal issues which do not reach the court. However wise a judge is, he cannot solve that. He's not able to. So that's one. The risk of overburdening Supreme Court, as in Poland. I see that's a fair risk. At the same time, it's a mechanism, at least in the Netherlands, with a high trust society, as Vice President Polak said. At least in the Netherlands, it's a mechanism to solve societal issues and to solve disputes which would not have reached it. So it takes more time now from Supreme Court, but in more or less, and a bit exaggerated, it's some kind of investment to prevent other cases and to hope that gives more clear for society. And the last point, is the Supreme Court acting as a quasi-lawmaker? Well, the simple answer is no, because it's the Supreme Court. And it's not, that's too simple. Because as we see in the Netherlands, if they receive a question based on this mechanism, they feel a bit more free to answer it than in a regular case. They're not bound by the system, they feel a bit more, now we can, let's unwrap this gift a bit. But so it's a bit, but it's not as far as a real legislator. And in the Netherlands, the issue of acting as a real legislator has not been raised at all. And I don't think it will be raised rather easily. That may depend on our legal culture, but it hasn't gone up as a real problem so far. Thank you.
I saw a question in the front row. Yes, please.
Thank you. Galic from Slovenia. There are different type of cases reach court. Some cases, the quality of decision doesn't really matter. What matters is that it is decided and that it is uniform and then followed and predictability. Will we drive on the right or the left-hand side of the road? But there are cases where the quality matters, and that's where I have certain problem with preliminary rulings, which is not the same as Professor Nekrosiu's concern. So for the first type of cases, preliminary rulings are okay. I give you 6, 7, or 8 points. The problem is that certain cases where the quality matters, which will have big impact on economy, on society, on behavior modification, as they would say in Scandinavia, reach Supreme Court prematurely. They have not been thoroughly discussed yet in the society. Take the binary, not now, but perhaps 3 years ago. And in the legal community, I mean, there is certain value that we have 2 instances before the Supreme Court. You can read and you can learn from the positions of the first instance court, second instance, and why not different positions? It was said as something bad if Rotterdam is this and Amsterdam that, or Tampere this and Helsinki different. That's bad for the parties, I mean the losing parties. That's in general for the development of law, that's not necessarily bad. I mean, humankind has developed through competition of ideas, dialectic discourse. Technical sciences, but social sciences as well. In the US Supreme Court, they often say, we are not wise enough, let the wisdom grow. We know there are different positions in the circuit courts. Take extent of arbitration agreement toward the non-signatory. Very important, no? They deliberately say, no, we are not wise enough. Let different theories, doctrines compete. Because once it is taken by the Supreme Court, we have seen in Professor Wu's presentation, it's built into stone, and it's suppressed. So my question that I build on the example of illegally obtained evidence. And I guess these are cases which would actually reach the Supreme Court. I take the argument that certain cases never will. So the wisdom will grow, but then you will not be able to show it. My question is, now you said we could have decided it 6 months earlier if we had this mechanism. My question is, would your decision be equally good? Because now you could have and learn and see different positions, different appellate courts, competition of ideas. And a question to Justice Polak. Have you, as a Supreme Court judge, I don't know if you were on Supreme Court Hoherat for this 140 cases, have you ever missed what you otherwise have in the cassation procedure, namely that you can learn from your colleagues? Unless, of course, I said that once in different audience, somebody said, how can you say that Supreme Court judges can learn from the lower courts? Well, okay, but that is then very hierarchical mentality. I think we can learn. And that's the dialogue. Dialogue is not, I ask, you answer, we follow. That's not a dialogue, that's very hierarchical. Dialogue is, we tell you what we think, perhaps different ideas, different... And then at a certain point, the Supreme Court intervenes and decides. So, question to you, Justice Lappen, and are you sure your decision would be equally good 6 months earlier? And to you, Justice Polak, have you ever missed what you otherwise have in the regular type of proceeding? Sorry that the question was a bit long.
Thank you very much for the excellent question. That is true. Through the normal channel, the case and the arguments are quite chewed in that stage. Of course, we don't have practice yet, so I can't answer from my own personal experience. But even in those cases, there will be the parties' arguments in the, for example, District Court and the Supreme Court. The District Court decision, in which it can give arguments on the case, and in many cases, for example, this which example I mentioned, it was highly debated in the legal community. So it would be more thoroughly argumented through the normal channel, but it is not argumented in those cases either. But I would say that if the question wouldn't be mature enough to be answered, then we wouldn't take it to be answered. As you mentioned, the US Supreme Court, then we would leave it aside in that case and perhaps wait some more mature cases and questions. Thank you very much.
So first, Judge, please, and then Professor Nekrošius.
Professor Nekrošius. And
observation, the development of law is a process of slow cooking sometimes, and the cooking takes place in courts of first instance and courts of appeal, and then gradually there's a role for the Supreme Court. So yes, we do have the situation sometimes that preliminary questions are raised too early, prematurely. That happened, for instance, in situations in a case where the question was, what do we do with, what's the English word for surrogacy, where, let's say, Dutch parents bought a child that was born out of a woman in another country. Can that create a fully legal relationship between those adoptive parents and the child? Because and what is the role of the biological mother who's living abroad? It is issues of private international law, recognition of family. Very sensitive area, of course, because there's the danger of trafficking in children, etc. That was a question that was brought to us at a stage where we thought, well, we have no ground to stand upon. Yet we have not declined to answer it. Well, we have limited ourselves to a few things, but for the rest we have tried to abstain from going too deeply into the field. We have, for exactly the reasons that you mentioned, let's leave it to the field to develop things, and then later on we will step in. So yes, questions can be addressed at a premature stage. We could use the formula and say, well, we don't admit them because they're not fit for answering. But we have not used the argument so far that it is too early. But maybe in the future we will be using that argument. I could very well imagine it. So I agree with you that I sometimes prefer the old-fashioned way of parties litigating all the way up, and then it's easier to be wise because you stand on the shoulders of other people. And if you don't have those shoulders to stand upon, you have to do it yourself, which is sometimes very tricky.
Professor Unriot Suregodar.
Professor, the floor is yours. I think yes, the quality won't change, or it will even improve if the case will go in a normal manner to the cassation. But for the sake of discussion, I hope nobody takes anything personal. As for the consumer loans, what are we going to do if they don't ask us about it? So what are we going to do if we receive this question? So we can't solve all of those problems. It's impossible to solve all of them. And my position is regarding that preliminary questions, and the rulings are signed by judges, and there are no co-authors, and I hope that there are no co-authors. Another question.
And excellent question asked by Professor Galic. At this point of stage, I'm neither opponent nor a big partisan to the system, and I'm trying to figure out the advantages and disadvantages. But I would like also to discard any parallelism with the procedure before the Court of Justice according to the Article 267 TFEU, or any preliminary rulings which might be asked to the constitutional courts internally as to the constitutionality of the law applied, because unlike in the preliminary ruling which we are discussing, the procedure before the Court of Justice is the single avenue by which the question of the interpretation of the EU law can be put before the Court of Justice, whereas here we have a completely ordinary avenue through all the stages to the cassation, to the Supreme Court. Another aspect which interests me is the following. The thesis was raised that certain cases do not reach the Supreme Court otherwise. And I'm asking myself, whether by introducing this procedure we do not put the cart before the horse, whether we really tackle the source of the problem. Why certain cases do not reach the Supreme Court? Why the consumer cases do not reach the Supreme Court? Perhaps there is a problem in the legal aid. Perhaps the consumer is too weak. Perhaps we should strengthen the associations, the mass claims, to allow the Supreme Court really to be accessible for this type of litigants. So the question is, have we really exhausted other ways to remedy the lack of accessibility to the Supreme Court otherwise? Thanks very much.
Thank you. Who would like to tackle it?
The Netherlands has a rather well-developed system of handling on consumer cases. On complaint boards, on complaint disputes, I cannot say we've tried all, but we've tried a lot. And it still turned out that it simply doesn't work. It concerns consumer cases because consumers don't want to put any more effort in it, any more money in it, any more time in it. But not only consumer cases, because the repeat players on the other side may have, let's say, incentives to settle for some reason. So it turns out that a lot have been tried. It simply didn't work yet. And as far as the fair point of Professor Galic is concerned, yes, I think you're right. Sometimes a dispute needs to grow and need to develop. We have no magical power to solve that. But at the same time, what we're trying to do by opening the door for third parties who are not involved, not the wisdom of growing, but in a certain way, the wisdom of the crowd. So that may, perhaps at some point, but everybody can bring forward their views. And perhaps it turns out that in a couple of years, the Supreme Court said, well, we need to review our decision. I think they're brave enough to do so.
Ir mačiau teisės Driukas turi klausimą. Prašau, paskutinis klausimas.
And the last question? We have time for 2 questions. I don't have questions. I want to support this mechanism and to oppose my friend Vytautas Nekrošius. I think that Mr. Nekrošius is opposing for the sake of debate. Because if we all support this tool, then it would seem that we all are for it and we would have no discussion. I don't agree, Mr. Nekrošius, that we have problems with the wisdom of our judges. I truly believe that we have independent justices and court system, and politicians have stopped intruding into the work of the judiciary. And I don't see any link between the introduction of the instrument and the willingness of the politicians to intervene into the judicial process. I believe that the objective is very good. We have many different cases, not only in consumer law, where, for example, claims do not reach the Supreme Courts. And we would achieve much more justice in such cases when, for example, we would give preliminary questions. Are the judges ready for that? First instance judges are dealing with the most complicated issues. They're referring to the Constitutional Court, to the Court of Justice of the European Union, and they're applying different bilateral international agreements, and this is a daily work. So this instrument is not a novelty for us. And in terms of threats, we need to discuss them. Yes, we need to adapt this instrument for Lithuania. And maybe the adaptation is not needed at all. There are certain criteria, there are certain safeguards for this tool, and these safeguards would protect us from the encroaching on the independence of the judges. So I think that we would give 12 points for the Netherlands and 10 points for Lithuania. And the last question. Thank you. My question goes to the Finnish speaker. For 5 years, I have worked in the Supreme Administrative Court, and I've been waiting for the new Prime Minister to propose such a tool. We are always fearful of all the novelties and new introductions in Lithuania. We have introduced many novelties in Lithuania that we were very anxious of, and now we see this advantage. And my question goes to the Finnish judge. You spoke about 23 cases and the reaction of the government by providing proposals to the parliament. In what way do you provide your resolutions? Is it in a form of guidance, or is there any other form, or simply you show or indicate the problem?
Thank you. I understand that you mean our proposal for this new legislation. So in Finland, it is in the constitution that the Supreme Court and the Supreme Administrative Court, we can make a formal proposal to the government to give appeal on new legislation. It is used very seldom, perhaps once in 5 or 10 years, but and we use it only concerning our own work. And this was the case where we saw the need for the proposal. So we made a concrete proposal, a formal proposal. We wrote draft paragraphs with draft arguments for them. And it is in Finland, it is given to the Ministry of Justice, and then it proceeded to the Parliament and it accepted it. So we have this kind of system in our country. So it was quite formal and quite well prepared, I must say. Thank you.
Thank you very much. Since we have limited time, and the discussion and debate is very interesting, not only because we're dealing with matters of law, but also of social matters, matters of the maturity of society. I'm very sorry, and I apologize to those who were not able to ask questions, but I would like to remind you that tomorrow you will have the opportunity to ask your questions, because we continue tomorrow. We start at 9:30 tomorrow, and we will be discussing other forms of achieving consistent judicial case law. Thank you. Have a good evening.